Good morning, good morning, good morning. It's Tuesday, it's November 5th. There was a new filing at the end of yesterday at some point from November 4th that we're going to cover because apparently Sarah Boone wants a new trial. We're going to go over what is going on in the Karen Reed case ahead of tomorrow's Supreme Judicial Court oral arguments. I will be covering those tomorrow morning, bright and early at 9 a.m. Eastern, 8 a.m. Central, in a hat. Maybe we all just show up in our pajamas. Maybe we do that. Maybe we just do court in our pajamas tomorrow. Maybe we just do that. Maybe we have like a court watching pajama party. But tomorrow morning, bright and early, we are going to cover the Supreme Judicial Court oral arguments. So we're going to go through what we need to know in the Karen Reed case leading up to that. Those will be pretty quick. The oral arguments are going to be, 45 minutes max, unless the judges have a ton of questions. That'll be a pretty quick hearing. So we will do that in the morning, tomorrow morning, Wednesday, before Wednesday's episode of The Emily Show drops. That is my breakdown of the YSL case and a few Diddy updates. Thursday, it is my deepest hope and desire to get into all of the music cases that we've been wanting to catch up on. That's our goal. So let's get into today. I had put up a poll on Instagram about some stuff that's going on with Tom Sandoval. We'll do just a little bitty bit of pop culture before we get into the Sarah Boone of it all and then get into Karen Reed. So just give me a moment to disassociate into the drama of the world of pop culture. Hopefully y'all come along with me. And as always, I know today is a busy day. I know there's a lot going on in the world. And I know that it's really nice to pop into a live stream and be like, oh, we're just going to talk about Scandoval. Perfect. Let's do that. Let's just talk about Sarah Boone. And that's what we're going to do today. We're just going to talk about the cases that are on the docket. So let's all do that together. Y'all cheers. Law nerds, we're here to do this. There's plenty of that out in the world. This is a moment where we can come and talk about the law. Cheers to all of you who have left lovely comments of like, I needed this about last week's food court. I did too. So I appreciate that. And I'm so glad that you guys are here. I adore this community. Thank you for all the lovely, lovely comments about, oh my God, food court. I needed it. I needed it too. I needed it too. So food court made me giggle. And I'm wearing one of my favorite floppy comfort shirts. Are we just dressing for comfort? Yes, we are. Yes, we are. That's what we're doing today. So I've got my coffee. We've got maybe some laughs. Maybe we're just going. I have not looked. I saw there was a Sarah Boone motion and I went, oh, bitch. This was my brain literally went, oh, bitch. And then I grabbed it. I did not even peek. I did not even peek at it. We're just going to go through it together, and we're going to go through it together and be like, is this what we're doing? Is this what we're doing? Maybe what? And then we'll do an update on the Karen Reed stuff, but I just can't not. I can't not. Oh, thanks, Dr. B.
Just a water boy.
I mean, you're a very cute water boy. I appreciate it. Do you want to tell them that the tumblers are also still buy one, get one? No, he's like, no, I'm out.
Tumblers are buy one, get one.
Thanks, Dr. B.
Yep.
So you can still get your tumblers. There are a few of the buy one, get ones left of the Law Nerd tumblers. Do I do this well? No, there we go. If you want to get the matte black and the iridescent, they're there. Thank you, Dr. B, for bringing water. Why? Because I was chatting with Judge Abby on her commute to work and then lost a little bit track of time and then grabbed this new file. And then I was like, okay, we're ready to stream. So let's roll the intro. Let's get into a little Scandoval. If you are sitting in the chat going, what the fuck's a Scandoval? I got you. I'm going to give you the briefest rundown, and then we're going to do all of the updates going on in Scandoval. If you want more updates on things going on in pop culture and law, I just recorded another episode of the Vile Files, and I'll share that with you. We're talking about the legal side of what's going on at Real Housewives of Orange County, because it involves a bookie and a dodger, and we talk about that over there. But it's time for a little pop culture for all of you that are like, I don't love reality, but I love the tea of a lawsuit. You're in the right spot. You're in the right spot because, well, there's some tea here, but is it really? We're gonna put up a new poll after we finish this poll, because we absolutely put Sarah Boone onto the docket for today. But we're going to have to take a poll if this is really a thing, or if this is Sandoval trying to CYA. Because, well, I'm going to let you tell me what you think. We're going to go through it and I'm going to let you tell me what you think, right? Let's get into it, you guys. Good to see you.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Okay. I'm going to do my best to explain Scandoval to our non-Bravo inclined law nerds as if I am in the style of junior high school lunchroom gossip. That is the goal here, because you are going to listen to any of you who have kids who come home and are like, oh my God, so-and-so did this. And you're like, I don't know who any of these people are. Just lean in. So, okay. Oh my God. So all of these like 20 somethings wanted to be actors in LA and started working at a restaurant/bar. All of them model actors, very pretty. Lisa Vanderpump had been on Real Housewives, but it was also a restaurateur and had a spinoff show. Why? Because you make a lot more money with your spinoff show with all of the attractive young people. And then you don't have to sit with a bunch of women screaming at each other. You get to just watch as those working at your bar restaurant all scream at each other and sleep with one another and throw drinks and are dramatic. If you go back and watch Vanderpump Rules now, because it's been on 11 season, you not only get some old tech, but you get like the rise of Instagram is kind of marked throughout this show as the early days Instagram. It's wild to see, but the early days Instagram, when they are just starting to have drama over who posted what on Instagram, who's got what pictures of who, and oh my God, we're out here and they're out there, and wild. So run up from early days of Vanderpump Rules, Tom Sandoval is dating Kristen. Tom Sandoval starts maybe hooking up with Ariana as he's breaking up with Kristen. Kristen was also hooking up with Jax, who was dating Stassi. Anyway, Tom and Ariana get together at the end of the relationship with Kristen and Tom. And then Tom and Ariana move in together. They're together like 9+ years. During that time, Kristen goes and dates DJ James Kennedy. Then DJ James Kennedy gets engaged to Raquel, who now goes by Rachel. So Raquel becomes besties with Ariana and then starts hooking up with Sandoval. This all is discovered when Ariana is at a show of Tom Sandoval because he wants to be a rock star and has a cover band that performs places. And his phone had fallen out of his, skinny leather pants pocket. And she went through his phone and saw what is alleged to be surreptitiously recorded. Tom says he had permission to record. Rachel says that she did not give Tom permission to record an intimate FaceTime video between the two of them. So with the intimate FaceTime video that is seen, everyone loses their mind because, of course you do when you find an intimate FaceTime video on your partner's phone. All hell breaks loose. Well, Rachel is at Watch What Happens Live, which is Andy Cohen's evening talk show-ish, and at Watch What Happens Live with another cast member, Sheena Shea. This all is breaking in Los Angeles at the end of Watch What Happens Live in New York. So there's a huge confrontation between Sheena and Rachel. Rachel says she's punched. Sheena says she pushes her. Rachel gets a cut on her eyebrow. Restraining orders are filed. I jump into the story because it's finally legal. And I'm like, we're off and away talking about Scandoval, which was covered from every media outlet you can imagine. And then the lawsuits. So while this was happening, we were at the beginning of, I feel like I'm talking about like 2017-18 beauty drama. So the reality reckoning was starting as Scandoval was breaking across the airwaves. And the reality reckoning seems to be headed by Mark Garagos and his partner, Brian Friedman, law partner Brian Friedman, who were representing and working with Bethany Frankel. And they were going to sue all of the Bravo lawsuits. Now, you might know Mark Garagos either from his current work with the Menendez brothers. He's been in every press conference you can imagine. You might know him from stealing my Uber. It's a joke if you don't know the story. We'll get to it maybe later. It was a members only topic. You might know him from representing Scott Peterson. Either way, Mark Garagos was spearheading the reality reckoning. Wait, we need
no, wrong one. That's not serious enough. That's not
the reality. Wait, maybe this one. It was no. Where is it? It was the reality reckoning. Reality reckoning. That might be serious enough. Reality reckoning. Anyway, spearheading the reality reckoning, there were a bunch of lawsuits. They were going to bring down Bravo, yada blah, whatever, yada blah, Andy Cohen. So then Rachel, who had the affair with Tom, who had surreptitiously recorded, and we're going with surreptitious recording because she says it was non-consensual. We don't know if is or isn't. I'm going with her side on this one. We're assuming it's surreptitiously recorded. It will all work out in the wash. We're assuming it's surreptitiously recorded. So the improperly recorded intimate video, Rachel sues Tom and Ariana. Ariana for distribution of the video, which is very much in dispute, and Tom for recording the video, which he says he recorded, but he said he had permission. We'll see. So she sues them. 3 pages of her lawsuit is about that. The rest of her lawsuit is throwing everyone under the bus. If you saw me break down that lawsuit, half of me covering that lawsuit is,
how does this apply to this lawsuit? What? How? DJ James Kennedy's not a good dog dad. What? Why is that in the lawsuit? Why is that in this lawsuit about Tom and Ariana? I don't understand.
And yes, DJ James Kennedy not being a good dog dad is part of the lawsuit, but it's not part of the lawsuit. It's just in the factual basis. What? So that lawsuit was all of the tea. And now we've gone through the legal motions of the lawsuit. There was an anti-SLAPP filed. There were motions to dismiss filed, all of the things. This lawsuit leaned into allegations and shade. And then, as if it wasn't enough, and then Tom Sandoval sued Ariana in a cross complaint in the same lawsuit. So let me get this straight. Rachel, who had an affair with Tom, sues Tom and Ariana for the video. And then Tom, inside the same lawsuit, cross complaints Ariana for the video, saying essentially, if you hadn't taken the video off of my phone, I wouldn't be getting sued. And the world lost their mind on Tom Sandoval, going, you cheat on the woman. You refuse to move out of the house. You refuse to sell the house. You throw her under the bus on television while giggling about it, thinking that you're not on a hot mic. And then you have the audacity to sue her. And everyone was like, you gotta be fucking kidding me. So Tom puts out, we covered this in another episode, Tom puts out a statement on Instagram saying, my lawyer made me do it. I had no idea. I didn't understand what this means. My bad. I didn't know. And fired the lawyer and withdrew and dismissed the countercomplaint. And he did. He dismissed the countercomplaint or the cross-claim, and he fired his lawyer. His lawyer, by the way, was Mark Garagos's brother. So there's that. So he now has a new lawyer. Apparently mowing the lawn on a Tuesday, not a Wednesday this week. Okay. Apologies if you can hear that. So that's been dismissed. But then Ariana sues Tom. This is actually a little bit ahead in time, but Ariana sues Tom over their mutual house. They lived in a house 50-50. And Ariana's like, sell the house. And Tom's like, I don't want to sell the house. And he's like, I'll buy you out of the house. And she's like, that's not an adequate amount of money to buy me out of this fucking house in LA. So there is a lawsuit going on over the house. The house lawsuit is set for trial in February 2026. In February of 2026. So they own a house together, 50-50. So she can't just sell it. He can't just sell it. Trial in 2026. The next court hearing in that case is set for February 2026. OMG. So the house, so all of you guys are going to be like, what's going on with the house? I don't fucking know. Ariana's living her best. She's bought a new house, got a new man, was on Dancing with the Stars, was on hosting Love Island. She's doing all the things, did ads for, you couldn't miss an ad from Uber Eats to batteries and toilet paper, all the things. But the house lawsuit is still ongoing. This lawsuit with Rachel is still ongoing. And here's the thing that's hard about the Rachel lawsuit. But first, we're going to stop and thank my friend Daniel, thank you for the gifted memberships. It's good to see you in the chat. Members only, you need more members. Thank you for the 20 gifted memberships. The law nerds can now illuminate themselves with the backstory of Mark Garagos stealing my Uber and, the Ringo versus Ringo lawsuit, because that is deep EDB lore in the members only spaces. So the difficult thing about the Rachel, Ariana, Tom lawsuit is that the laws in the kind of revenge distribution of images space are not well vetted. They can be difficult to parse, and distribution in that context yet is not well defined. So is Ariana taking the video off of Tom's phone and sending it to her own phone distribution or not? Because Ariana says she sent it from Tom's phone back to Rachel's phone. So from Tom's phone to Rachel's phone, is that distribution? Because she sent the video to Rachel and said, what the fuck? And so is that distribution under the law? Is it not? But also, don't surreptitiously record people on video. Should Rachel have been hooking up with her friend's man? No, she shouldn't have. Should anyone be recording her without her consent? No, they shouldn't. Should that be distributed without her consent? No, it shouldn't. So does the lawsuit pose some real questions? Yes, it does. But is it, in the court of public opinion, a bad look to turn around and sue the person whose partner you were sleeping with? Yeah, it is. Does that mean Tom didn't do anything wrong? No, it doesn't. So now, because of course this needs to come up now, Emily, is there anything going on in this lawsuit that would warrant Tom Sandoval needing to talk to Page Six? No, there isn't. So why is Tom Sandoval talking to Page Six right now? I don't know. He and Ariana are both appealing the last court rulings with regard to the anti-slap and the motion to dismiss. So why does Tom need to be chatting to Page Six about this? I don't know. Maybe because nobody's talking about him. You let me know in the chat. Why is Tom bringing this up now? Everybody has other things to talk about. The news cycle is full, Sandoval. But yet we're here. Why? Because we're trying to make our news cycle less full. We just want to talk about reality television for a minute. So let's talk about it. Coming to us from Page Six, exclusive. Famed lawyers behind Reality Reckoning accused of enticing Tom Sandoval to point the finger at Bravo. Oh, you know why? Here's why. Because he's pointing the finger at Mark Garagos, and Mark Garagos is all over the media right now talking about Menendez. So the Garagos name, not Gyarados the Pokemon, Garagos, I think he says Garagos. I've always, whatever. I think that's why, because it's in the media right now, and page 6 is like, hey, do you have any of those clicks and views? Do you have any of those clicks? Do you have any of those clicks? Do you have any of those clicks? So let's see if this is really accurate. Amy Skull in the chat said, is Ariana that EDB talking about Ariana Grande? No, it is Ariana Maddox from Vanderpump Rules, not the ponytail herself. All right. The high-profile lawyers leading the so-called reality reckoning are accused of trying to cajole Tom Sandoval into implicating the campaign's primary target, the reality giant Bravo. Do you know who Rachel didn't sue in this lawsuit against Tom and Ariana? Put it in the chat. Bravo, fucking Bravo. Bravo, fucking Bravo. Bravo's not sued in this. Andy Cohen's not sued in this. The production company's not sued in this. This is Rachel versus Tom and Ariana. Not Bravo, not NBC Universal, not the production company. None of them. Bravo alum Bethany Frankel, who was all up in Dunkin' Donuts comment section. Go to food court from last week. Bravo alum Bethany Frankel, along with Brian Friedman and Mark Garagos, noisily launched. Page 6 is like, if you take away Bravo, we have nothing to talk about. Yes, Dr. B.
I hate to interrupt you.
It is. Is it about all of the mowing going on? Because there is so much aggressive mowing. All right, Dr. B needs to say hello. I'm going to leave you with this.
It wasn't urgent.
I understand if it's urgent. Give me 30 seconds to tell the law nerds what. I'm not just going to go radio silent. Law nerds, Dr. B has a urgent matter. Give me just a moment to see what that is. Look, and you're going to have to look at Tom's smug face. I apologize. Dr. B is going to go get the ukulele for later in the show to apologize for the interruption, and we'll go from there.
Tiny bubbles? Am I going to do tiny bubbles?
No, you're going to do Toxic Gossip Train. You don't know it. We'll talk about it. Give me 30 seconds, chat. Oh, thank you, Miguelina. Sorry for the court break, y'all. Dr. B was like, everything is fine. But Dr. B has his new car. Yes, we do. We need emergency paging Dr. B. Emergency. Paging Dr. B. I know we do. I know it's a busy day, y'all. So apologies. All right. Are we ready to move on? Sorry, I think Miguelina was like, what the chat doesn't need is to look at Tom Sandoval's smug face. Miguelina, I 10 out of 10 support that production decision. I think that they do too. So Natalie V in the chat said, I love that you pause your streams for family. Look, here's the thing. I have the incredible blessing and opportunity to work at my house. Some days that means that they're here to mow the lawn, probably because weather tomorrow is not conducive, but I have the ability to work at home. There were so many times where I could not move court for things with my family that I wish I had had that kind of control over my life at that point. Everybody has to make those decisions about how to put things first and how to prioritize. And there are times that there aren't really options. I mean, there are, but you're like, if I get fired, how will that affect my family? So there were times I did not have as much control over my life as I wanted, and shifting my work has allowed me a little bit more of that control. And so if we need 3 minutes, then we need 3 minutes, and it's all going to be okay. But we've also rearranged family stuff for streaming, and my family's been very patient. So we try to balance it so that it's a how we find the balance between what family needs, the content that I want to cover, and making sure that we can cover trials, but we're not covering all of the trials, so that we still have family time. Because look, life is short and tomorrow's not promised. And so I'm going to absolutely do what we can. So yeah, we're going to do what we can because, real life is real life. But also, we're going to talk about other people's real lives that we don't have to deal with because my life is boring. And this is so messy that we're just going to talk about other people's messy lives. My life is incredibly boring. The messiest thing that has happened in my life, do you want to know the honest truth? The messiest thing that has happened in my life in the last week is that I was unaware of the brutal and violent shift in the Dunkin' Donuts menu. The second it was November 1st, pumpkin was gone. The pumpkin donuts were gone. And of course, this is as my kid, I don't like donuts, I don't like pumpkin, loves all of the donuts and all of the pumpkin. So on November 1st, I'm like, let's go get some pumpkin donuts. It'll be kind of like end of the season as we switch. Fuck no. All of the Dunkins around us are already on their holiday menu. They were like, bitches, it's Christmas now. I'm like, God damn it. It is not yet Christmas. It's November 1st. Can we at least roll through Thanksgiving? It's just barely pumpkin pie season, Dunkin'. Can you stop? Christmas will have its time. This was also me at the last minute going to get Halloween candy. And all of the Halloween candy was shoved to the back of Target. And they had all of the Christmas decorations in front of where the candy was. So I was like, excuse me, can you just push that to the side so I can I just get the fun size Snickers, please? That's it. We just miscommunicated. I've covered a trial. I forgot what month it was, but it was all of the Christmas stuff blocking on the 30th of October. I was like, it's too soon for me. I am never going to shade those of you that are like, it is November 1st, put up the Christmas lights. Lean into your joy, people. I need it to be pumpkin I orange and brown season for just a little bit longer. Like football's not over yet around here. We're still in football. I need to not do Christmas from November to like January for me. I need a little more pumpkin time. So I was not ready. I was not ready for it to be like November 1st, Christmas menu. I was like, what the fuck? Can we just not? Anyway, back to messy lives that don't revolve around. Tom Sandoval's like, bitch, you need to stop eating the Dunkin' Donuts. I know. Look, man, we're almost 50. We're living our lives one day at a time. So I saw Attractive Nuisance in the chat say football goes to February. I'm pacing the seasons of my life by high school football schedule because my kid's in band. So high school football. For those of you that are like, it snowed at my house today. It's too early for snow. We're just having another like wind and warm wave over here. All right. Let's talk about the reckoning, the reality reckoning. Bethany Frankel got the lawyers, Brian Freeman, Mark Garagos. By the way, those are the lawyers that Rachel was using to sue. I have to wonder if this conversation happened when Rachel was on Bethany's podcast to talk about all of this, because Rachel went on Bethany's podcast, which was a huge bump to Bethany's podcast, and then launched her own podcast, which I don't know how her podcast did. I'm sure she enjoyed having a microphone during the last season. I think that podcast is now probably on pause, but whatever. If you want to step away, step away. It's fine. This was all probably a mess. And, it still continues to be. So, Bethany and the lawyers promised to make NBC Universal pay for its alleged grotesque and depraved mistreatment of its stars. The reckoning appears to have made little headway since then. Page 6 coming in a little shady. Vanderpump Rules star Tom Sandoval claims the lawyer behind the reality reckoning offered to drop a lawsuit against him if he offered to help point the finger at NBC Universal. All right. Does anyone want to play issue spotting with me? All of our law students and lawyers in the chat, all of our savvy law nerds. Anyone else want to play issue spotting with me? Where does this sound like it's an issue for you? Let me know. We're going to keep reading, and then we're going to get back to where do we feel like this is an issue. By the way, I think this is a Menendez press conference because they're out in front of HOJ, which is not even where this case takes place. Attorneys Brian Freeman Wright and Mark Garagos launched the crusade against ABC or NBC Universal. I'm in reader mode because there are too many ads. Let's see. Scandoval tells Page 6 that Garagos and Freeman offered to drop the damning lawsuit against him if he were willing to, quote, point the finger at NBC Universal and help them build their case that the company concocted the storyline that would humiliate their client, the Vanderpump Rules star's ex, Raquel Leviss. So Leviss, I think the second one is right. These are settlement negotiations. So if these are settlement negotiations, generally settlement negotiations are quiet. These types of settlement negotiations aren't wild. We've seen these types of settlement negotiations in cases we've covered. Hey, if you become a witness on our case, we'll stop suing you because then you'll be a witness in our case. And part of our settlement agreement is that you become a witness in our case. The feds do this all the fucking time. It's like, well, we can prosecute you, or you can tell us what you know and help us prosecute them. But these are settlement negotiations, which are generally private. You normally see the ramifications, like you see a lawsuit dropped and then you see a name show up on a witness list and you're like, well, yeah, obviously that's what happened. So they are trying to get Tom to back Rachel's claims against NBC. Why do I think this is happening? Let's speculate for a minute. Who's got more money? Just let's follow the money. Remember our when you have questions, follow the money first. Let's follow the money. Who's got more money in this? Scandoval or NBC Universal? NBC Universal. So, of course, Rachel's lawyers want Tom to say, hey, we were in all these conversations together, and NBC Universal, this is what they want for Tom. I'm not saying this is true. Note, asterisk. I'm not saying this is true. I'm saying this is what these attorneys want. They want Tom to come in and say, yeah, I worked with production. Yeah, production said this and this and that to me. Yeah, we knew it was going to be bad. Yeah, we knew it was going to be this. And these are the conversations that production had with me, maybe conversations that Rachel wasn't a part of. And then at some point, Tom would have to admit, and this is what I did to throw her under the bus to save my own ass on this show that I've been on for 11 years. So Tom, I think, wanted to come out of this looking like the good guy. And so was Tom willing to throw her under the bus? I don't know. Maybe he was, maybe he wasn't. Or maybe it was Rachel that was like, hey, fuck you, Tom, I'm out. Like, and Tom's like, but imagine what this will be like for another season. Let's go. Content, let's go. And she's like, this is my life. My mental health is suffering. This is not a let's go. Tom was like, no, imagine what the next season will be if you and I just link arms together. Imagine. And that solidifies his place on the show, right? So I think they were saying, join forces with us. Come to the dark side. We've got cookies and we'll drop the lawsuit against you. And then it would be Rachel versus Ariana only. It seems that didn't happen, but these are settlement negotiations. Are we surprised? No, I'm not surprised that these were the settlement negotiations, but these are settlement negotiations. So Tom is now saying why, I don't know. Who knows why Tom needs to talk about this? Tom is now saying he was being cajoled to join their side. This isn't unusual in settlement negotiations. It's why they're private and not held against you in court. In 2023, reality fans were gripped by Scandoval, in which it was revealed that Scandoval had an affair with co-star Leviss, behind the back of his longtime girlfriend, Ariana Maddox, who also starred on Vanderpump. We know We know this, I summarized all of this. Let's see. Sandoval alleges that sometime around the summer of 2024, Friedman and Garagos approached his attorneys, Varvind and Tara Karaminas. So this was after he left his other attorney then, because he fired his other attorney June. So after he fired his other attorney, Garagos's brother, and part of their Gorgian law group offered the quid pro quo. Well, it's a settlement offer, and the settlement offer is normally, if you do this, we'll do this. Let's find a middle ground. That's how settlement works. Everybody's in civil suits. Oftentimes, everyone's a little unhappy with a settlement offer. That's how you know it's a compromise. Everyone's a little like, well, I don't love it, but it works. My lawyer said to me, also, Tom, are we going to start breaking into attorney-client privilege? Because sharing what your lawyer said is going to open some doors that you might want to keep closed, my dude. My lawyer said to me, not a good way to start a sentence. They gave you an offer. I know you're not going to take it, but I have to bring it to you. That's facts. If a settlement offer is made, you have to communicate it to your client, even if it's something they're never going to do. If you point the finger at NBC Universal, they'll drop the case against you, he tells us. Sandoval 40, he's also the one who said, my lawyer said countersue Ariana, and I didn't know what that meant. Sandoval 42 claims that his lawyers asked whether he would be willing to say agents for NBC Universal had put him up to revealing the affair to Maddox 39. Okay. Is that true though? Like it has to be true though. Is that true? A representative of the law firm told us, quote, we are unable to comment on settlement offers made to our client, but it is my impression. We're unable to comment, but here's our comment. But it is my impression that from the outset, Levis planned on making the studio her real target, as evidenced by various passages in the lawsuit they filed against Sandoval and Maddox. But they don't have enough to do that. Sandoval has consistently stated that the studio had absolutely nothing to do with the unfortunate events that unfolded. Well, right. Are you going to protect the job or not protect the job? Sandoval claims the lawyers wanted him to say that NBC Universal put him up to revealing the affair to Ariana. When asked about the claims, Garagos and Friedman said, quote, Tom claims he lost his phone. Tom claimed he lost his lawyer. Tom did not, in fact, lose his motion to dismiss. Tom did, in fact, lose his motion to dismiss, which he's now appealing. It now appears he's lost his mind. How much time do they sit and think about the quips? Because they are quippy with the media every single time. The subheadline needs to be, Levis lawyer says Tom Sandoval lost his mind. And then in parentheses, page 6 wants you to be clear that Tom Sandoval didn't really lose his attorney. He fired his attorney he had hired to work on the case after the attorney sued Ariana. In a 2024 letter promising that a day of reckoning had arrived for NBC Universal, which owns reality-heavy E! Networks, Garagos and Friedman claimed they had a significant number of individuals ready to tell their stories, but they have yet to file any claims, and as page 6 reported recently, they dropped out of representing Real Housewives star Brandi Glanville against Bravo. The lawyers sent separate letter to NBC Universal telling the company and Bravo figurehead Andy Cohen to prepare to be served a suit over the way they treated Glanville during her time on Real Housewives of Beverly Hills and Ultimate Girls Trip, but that also did not pan out. So why is this coming to the media now? Is it just because Garagos and Freeman are in the media over the Menendez brothers and their names will drive attention? Does Sandoval really need his name back connected with this? Like, how many times do you want your name to show up when somebody Googles revenge porn? How often do you want Google to just connect those two with your name, Sandoval? Because the more that this happens, the more connected they are. So, why now? Also, this case is all on appeal, and it's going to take forever because Ariana is appealing the anti-slap. We'll dive back into that when all those appellate briefs are filed. I'm going to wait until all the appellate briefs are filed together unless there's something incredibly stunning that we need to cover. But I'm interested to see how the anti-slap shakes out, because this is not the typical case for an anti-slap. It's not a defamation suit. So is Ariana's sending of a video to Rachel saying, what the fuck, a protected form of free speech, or is it distribution of an illicitly recorded video? I think there's some legally very interesting questions there. It's not going to feel legally very interesting to all the parties paying a ton of money for this stuff, but for us, it's I think a legally interesting question. So we will go through all of that once all the appeals are filed. Do you guys want to talk about Sarah Boone next? Should we talk about Sarah Boone next? We'll dive into the deep legal of all of this later. I think it's actually really important to go through the definitions of what this surreptitious distribution of videos is like, and to remind everyone that no one has the right to record you intimately without your permission. Of course, if you are in a public place, people can record. There are asterisks, but you know what I mean. In these contexts, it needs to be discussed that even if they are your intimate partner, they shouldn't be doing this. So yes to Sarah Boone, and then we'll summarize Karen Reed afterwards. All of you are like, yes, 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 yes. All right, let's talk about Sarah Boone. Did you watch the trial? Here, let me put in a quick poll. Did you watch the Sarah Boone trial? Is our poll yes? No, please. I'll probably summarize anyway. No, I won't. I'm going to start reading the document and see how they summarize. And then if we need to supplementally summarize, we will. Lisa, thank you for the 5 gifted memberships. L444, thank you for the gifted membership. Green, thank you for the gifted membership. Thank you guys for the gifted membership. Appreciate it. Jen DeSimio said, I turned 50 last Saturday. I'm embracing it. Look, man, our brains are still in the 20s. Our knees are somewhere upwards of 45, and it's just fine. It's just fine. Look, there are days I'm just like, how did we get so old? And then there are days that are like, I have done a lot of shit in my life, and that's kind of exciting. Though compared to all of this, my life has been incredibly boring. And I am thankful for it. I am not a person who strives on excitement. It makes me feel unmoored and like I don't know what's happening. Maybe that's the neurospicy. It makes me feel like I am missing something or out of the loop. I don't love it. I don't need that level of excitement. Let's talk about Sarah Boone. 95% of you are like, yes, we watched the Sarah Boone trial. 5% of you are like, please summarize. If there's not a good summary at the very earliest stages of this motion, I will do a summary. I'll do a real quick summary anyway. We'll just do a little one. State of Florida versus Sarah Boone. Look, the thing that blew me away about this trial was, one, how nonchalant the DAs seemed throughout the entire trial. And then we got to rebuttal and I was like, oh, which is why I always say, I never know what they may have. We don't know all the evidence till it comes out. So you never know what they're relying on. This case, particularly so. The state was particularly chill. And then they got to their rebuttal case and just pushed play. And we were like, oh shit. Well, that's why you were so chill about everything. And the state was just like, we're just ready to go to trial. The Sarah Boone trial lasted about 6 days. She was convicted of the second-degree murder of her boyfriend, George Torres, for zipping him into a suitcase and leaving him there. He told her that he could not breathe. He told her to let him out. He tried to get out, and she prevented him from doing that, and then went upstairs and went to sleep. And the next day was like, oh. So she was convicted of second-degree murder. The jury was out like an hour and a half. I think they spent an hour eating dinner. This, again, do I speculate often? No, but when I do it all in one episode. Do I think the jury generally knew early on in their deliberations what they were going to do? Yes. Did the jury have dinner in the back? Yes. Did the jury probably want to talk about the case a little? Yes. Have I also seen juries that have said, well, we had a verdict, but it felt like it was too fast to come back, so we just chatted for an hour because it felt like maybe it seemed like we should give it a little bit more time? Yes. Jurors are like, does it look bad if we're just like, we're done? After 6 days of trial, does it look bad if we take 3 minutes to do this? Maybe. So sometimes you have jurors that want to chat with each other. Throughout the entire case, they can't chat about the case. So it's not unusual that the jurors might be like, hey. So I think they probably ate dinner, chatted, had a verdict, continued to chat until they were done, and then came back with a verdict. They're like, all right, hour and a half seems good enough. Let's go. It just, we gave, like, send it. It's 8:00. So yeah, I think they could have probably come back faster on that, but I also think they maybe wanted to have a moment, because imagine not being able to talk about all those videos. You got to wait till the end of 6 days to talk about it. So, Sarah Boone. So now, well, yesterday afternoon on November 4th at 4:57 p.m., Sarah Boone filed a motion for new trial. If she says in here that it was unintentional, I'm going to fall over. What else? What else could Sarah Boone say in here? My lawyers didn't. Like, what are your grounds for new trial in these 5 pages? And who filed this? Let's see. I'm going to zoom to the end real quick. What lawyers filed this? James Owens filed it. Okay, James Owen. Let's see. Let's see what we said. Defendant's motion for new trial comes now. Sarah Boone through counsel. Defendant was found guilty as charged on the second-degree murder, October 25th, 2024. The motion is timely filed. I don't dispute that. Defendant asserts, tell me. Defendant asserts that she is entitled to a new trial under Rule 3.600 on the following grounds. The court erred in ruling that defendant was not entitled to court-appointed counsel. Bitch, really? The court erred in denying undersigned's multiple motions for continuance. The court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. You guys called all of these. The trial court failed to disallow the opinion testimony of the state's rebuttal expert, Dr. Tanya Werner. After the state failed to disclose before trial that the witness had formed a new opinion, and the state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Okay. So we're going to go one by one. So the last one, the second closing argument instead of a rebuttal, it was a rebuttal. They rebutted what was brought up during the defense argument. They just did it well. You know that the defense is mad when your rebuttal is so good. They're like, that wasn't a rebuttal. It was too good. The rebuttal went to the things the defense said in their closing. Owens, go watch the tape back. You're mad because it was good. Okay. We'll talk about the state's rebuttal expert witness, because those are the grounds, the types of grounds we will normally see in a motion for new trial. That's the type of thing you would normally see. These aren't narrowly tailored though. So I would lose the last one. I wouldn't have even brought it up. I would probably lose this one, but again, I'm not the defense attorney. The court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst. They didn't cause an emotional outburst. They had an emotional outburst, and I don't even know what kind of emotional outburst it was. It sounded like they sniffled or cried, and then they were escorted out of the courtroom immediately. I don't think that's going to have a substantial impact on the jury, because I don't think they knew that that was the victim's family. And even if they did, those videos were hard to watch. So anyone might have an emotional response. An emotional outburst in court that would be a problem could be shouting an opinion, saying something to the jury, rushing the defendant, not being able to stifle a sob or what have you is not really going to do it here. Also, the defense didn't put on the record clearly who it was and clearly what happened. They tried to, but they didn't make a record of exactly what happened because I don't even think the defense heard it. There wasn't a super clear record on that because we were all going, what the fuck happened? The court erred in denying the undersigned counsel's multiple motions for continuance. How do you think the appeals court's going to feel about that? The Court of Appeals is going to be like, they told you. They told you. Also, I think juries are savvy enough. I think, and I generally am a fairly optimistic person, even though working in a really difficult career. I do think as a whole, people are able to separate an emotional response from someone in court to a difficult video and separate that from causation. I don't think anyone's going to be like, well, look at that reaction. She must be guilty. I think people can look at that reaction and be like, yeah, it is hard. But if Sarah Boone didn't do anything, if Sarah Boone didn't cause this, I think a jury might be able to separate the two. And I don't think how somebody in the audience acts is necessarily going to sway a jury. Is it ideal? No. But I think considering the videos that we saw in the rebuttal, it doesn't even fucking matter. Does it? Does it matter? After those last videos, does any of this matter? Any of them? How many of you forgot that happened? And number one, the court erred in ruling the defendant was not entitled to court-appointed counsel. I'm not surprised that this came up. These are grounds the court is going to deny them. Remember, this motion for new trial is going to come before Judge K. So, while I might think that all of the grounds are not well taken, we get to see Judge K go over this again. And for that, Owens, we thank you. Thanks, Owens. Let's have this on calendar. Let's go spend another day with Judge K. Let's let Judge K's face go through all of this again. Because Judge K is going to be like, I told you, or I told her what was going to happen. I told you what was going to happen, and you parachuted into this case at the last minute. Like you just couldn't help yourself. And we told you trial was going, and then you got an extra week. We told you. The court is going to briefly address whatever their alleged emotional outburst is. And the trial court failed to disallow the rebuttal expert. The court held an entire voir dire on it and said, Owens, this is your chance. The court gave Owens multiple chances. Owens, go ask him whatever you want. Owens' cross-examination of the expert when they had the voir dire of the expert was better than his cross-examination in trial. Well, that's not the court's fault. All right, let's see. Law and argument. Argument number one. The above styled number case, the defendant had approximately 7 court-appointed attorneys prior to the undersigned counsel taking her case. Undersigned counsel took the above case because he was concerned. I don't care about your feelings, Owens. You chose to do it. I don't care why. That's between you and your lawyer. You could have opted out, but no. Because he was concerned Ms. Boone would not have an attorney to represent her at trial. That's true. That would have happened. That was on her, though. Did this judge not give Sarah Boone every possible opportunity? And Sarah Boone wrote letter after letter after letter to the court, disparaging her lawyers, name-calling her lawyers, just all of it. So, okay, counsel. Ms. Boone would not have an attorney to represent her at trial. The above case was very complex, even for a seasoned trial attorney who was the public defender of the First Judicial Circuit for years, as well as having a thriving private practice. So you're going to glaze yourself in sentence one. Awesome. Awesome. I now sound like my 16-year-old. Awesome, Owens. Your Honor, even for an attorney as amazing as myself, this was a complex case. The most complex thing about this case was Sarah Boone. She was a complex individual. She is a complex individual. However, the videos kind of speak for themselves. So those videos speak for herself. In the chat, Goose Toots asked, what was her sentence? She has not been sentenced yet. She will be sentenced in December. I imagine this will come to hearing before that. And let's get to the end of it before I say this will probably be denied, but also most trials, most motions for new trial are denied, and then there will be an appeal. But they are bringing a motion for new trial. They brought their motion for judgment notwithstanding a verdict orally. The court was like, and denied. So this will come up before the sentencing in October. We'll see when the court puts it on calendar. The prosecution will have a chance to write their opposition. The defense will have a chance to write their reply, and then the court will calendar it. So he said the above case was very complex. I think the amount of time they had maybe made it more complex. The facts of this case are not complex. Did Sarah Boone zip him in his suitcase? Yes. Did she leave him there? Yes. Why did she do that? That's it. Sentencing's in December. December, next month. It was apparent to undersigned counsel, they continue, that Boone would be grossly ill-prepared and unequipped to handle a trial in this matter, or in fact, to handle any other phase of the trial without counsel. Do you think Sarah Boone approved that sentence? Sarah Boone's like, I'm amazing at everything I do, and I would have made an amazing lawyer. But she wanted a lawyer. She wanted a legal team. She seemed to me to be happy to have a legal team. People should have lawyers. Lawyers are going to make arguments that Sarah Boone would not have made. I agree with that. There are arguments that Sarah Boone would not have made that they were able to make. But after we've seen the whole trial, does it change anything? Sarah Boone might not have brought the battered spouse defense, and if she didn't, the videos in rebuttal might not have come in. Would that have been the better play in this case? Chat, let me know. Would it have been the better play in this case to take the trial strategy that keeps the videos from rebuttal out? Is this case different if you don't see those videos at the end of the case? And is there more of a question of, wow, was she really just that drunk? Was it really just a day gone wrong? Does it leave that question in your mind of maybe this really was just like her being drunk and them being terrible? It doesn't change the second degree, but maybe there's jury sympathy there for the manslaughter and not the second degree being like, man, I do think she was really just that hammered and she shouldn't have left in there, but she did. Does it get worse? Does it get worse when you run the defense? Maybe. But it was apparent that Boone would be grossly ill-prepared. Boone's like, fuck you, sir. I excel at everything. Me in my head having a full conversation. You guys, what are the chances Boone writes a letter to the court to take issue with this? What are the issue? What are the chances? What are the chances Boone writes a letter to clarify? Court goes on to say the Sixth Amendment and Rule 3.111 of the Federal Rules of Criminal Procedure guarantee an indigent defendant the right to appointed counsel. Counsel, but that right is not absolute, which we have heard a lot in this case. There appear to be two exceptions to this procedure. One, if the defendant physically harms or threatens to harm his or her counsel. Didn't she try to do that? I wonder if her counsel felt psychologically tormented. If the trial court certifies that the defendant will not be incarcerated if found guilty. That's not the case here, but this right is not absolute. Should the court determine that the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant, the court must follow a process. Are we going to need to go back and revisit the pretrial of this case? I feel like we might need to go back and revisit some of this in light of this motion. Just like we revisited sidebars, I feel like maybe we need to revisit some of Sarah Boone's letters. We might need to revisit this hearing when the court declared her to represent herself. We might need to hindsight this a little bit. So Lauren M in the chat said, I would enjoy it, but I don't wish that on you. I'm kind of curious though. I don't want to run down the rabbit trail of my own curiosity if you guys aren't curious as well. But I feel like we might need the context. Maybe we'll put up a poll in the YouTube spaces later. So maybe we'll do that. We don't have sidebars yet for this trial. All right, let's keep going. Don't worry, it's not going to be this week. But I also have some planned for some extra members only this month and next month. We've got lots coming for you guys. Okay, that I'm excited about. You guys are curious. We might need to. Yeah, we might need to. All right. Edward said, Emily, don't you know that C in chat is for curious? Yes, chat is like, we would love to know. Even the chat that's like, we've already gone through this. We just want you to go through it.
Bruh.
Steph Zoom said, bro, we're neurodivergent. Of course we want to hyperfixate on the lore. That's the answer then. 10 out of 10. You guys are like, we need to do it. We will do that. We will schedule a stream to just go through the backstory. Don't worry. For those of you that are impatient, Peter over at Lawyer You Know has covered tons of this. I wanted to go into the trial. We'll backfill, just like we're going to do a little bit today with Karen Reed as well. Okay, let's see. Where's our summary so far? The defense says he's great. Boone was ill-prepared. He shouldn't have taken away her lawyer. She's guaranteed a right to a lawyer. He goes on to say, should the court determine that the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant, the court must follow a process which protects the individual's rights. There was like a very thorough hearing on this, and there were lots of warnings. In this case, undersigned trial counsel would assert that Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court-appointed counsel. It'd be really interesting to see an appellate court walk through this. I would be very curious. If the court determines that she waived her right to court-appointed counsel, then the court failed to warn her or inform her that her continued misbehavior would result in waiver of the right to court-appointed counsel. We're just going to have to go through and see what the court said. Under controlling precedents, failure of the court to appoint trial counsel can result in a motion for new trial being granted. The thing is, though, that at the end of the day, she had counsel. Does that negate this argument? Because I feel like the judge repeatedly said, ma'am, if you cannot work with counsel, then you will not have counsel. Like all the way through. Also, you had counsel. Argument number 2. The court erred in failing to grant defendant's motion for continuance. The court shall not deprive the defendant of his or her right to counsel of her own choice. Right, but she couldn't afford counsel. So she couldn't hire counsel because she couldn't afford counsel. And then she couldn't get counsel appointed because she refused to work with them and was like name calling them and shit. Failure of the trial court to grant a continuance will result in a new trial should the court deny the motion for a continuance by new counsel. I think there's probably more to that. I think there's probably more to that case than that. These circumstances were fairly extraordinary. In this case, when undersigned counsel came on board, the case was 4 years old. Undersigned counsel filed the notice of appearance August 30th, 2024. This gave counsel 45 days to prepare for a second-degree murder trial. But you have a thriving practice and you've been a defense attorney forever. You knew what you were stepping into. It's a lot of digital evidence, but you knew. He immediately and aggressively began to prepare for trial. Undersigned counsel did his best to prepare to trial by traveling to Orlando from Milton on multiple occasions. Dude, you chose it though. Nobody thrust this upon you. You weren't appointed. The court didn't grab you out of Milton and say, you must be in Orlando. Sarah Boone needs you. Like, you chose to do it, sir. This was your choice. Undersigned counsel did his best to prepare for trial. Despite his best attempts to prepare for trial, it was impossible to adequately prepare for unforeseen issues arising during trial. First, you volunteered as tribute. Second, all trials have unforeseen issues no matter how long you've had the case. Third, you have enough experience to know what can pop up in a given case, and you chose to run an affirmative defense. A prime example of this would be reviewing hundreds of pages of text from Miss Boone's seized cell phone and viewing all records of prior contact of Miss Boone and the alleged victim with law enforcement, including inadmissible hearsay by the victim and law enforcement. This motion's going to call George Torres the alleged victim the entire time. If I ever say victim instead of alleged victim, it's because my brain has just skipped over the word. It's not because that's what's written here. So if I misread, I'm sure you understand that my brain has just like yeeted the word alleged a couple times. So just know going forward, if I use them interchangeably, the motion is consistent. I am not. Because it bugs me. So they're saying that they had to view all the records of prior contact between Boone and George Torres with law enforcement, including inadmissible hearsay by the victim to law enforcement regarding Boone being the aggressor at times. Counsel for all purposes. You're the one who elicited from your witness, no, from the state's witness, that Sarah Boone was the aggressor according to her ex. You asked that question, like you're the one who put that out there, but I don't think it even matters because of the videos. Counsel for all purposes closed his law practice down to prepare for trial. Miguelina, can you make a note? We need the world's smallest violin noise. We don't have one yet, but we need the world's smallest violin. Like, we need a world's smallest violin sound on here. We just need it because right now this is the best I've got. This is the best I've got.
Bruh.
I feel like I need a bed of dramatic music. Just y'all are neurospicy. Just insert world's tiniest violin music into your head now. Counsel for all purposes closed his law practice down to prepare for trial, but due to the short time frame, even with the assistance of other attorneys and the girls, was simply logistically unable to be as prepared for trial as he would have liked to be and as Miss Boone was entitled to. Under the controlling cases cited supra, the court's failure to grant undersigned counsel's motions for continuance should result in a new trial. Counsel, you chose to take this case knowing what it was. In the chat, I see a number of you asking, does this say the girls know it? No, it does not. I inserted that for snark. So he's like, I was not as prepared as I would like to be. They had a fucking fleet of attorneys a fleet of attorneys. And let me tell you, preparing for trial is not easy. I have never worked a case with that many people helping. And you can be prepared. You're never going to be as prepared as you want to be on a case with this much digital evidence. But I guarantee you, a lot of those lawyers that he worked with, somebody read all of those text messages. The way that digital evidence was my favorite thing to comb through, because it's just being nosy. It's like, give me the tea. What's everybody saying in the text messages? And you just go through it and read them all. Just all of it. Reading through the tea is not hard. That's the fun part of prepping for trial. But somebody else was watching these videos. He had so much help here. Multiple assistant attorneys, multiple co-counsels, more than any public defender, more support than any public defender would have. Y'all, his motion so far is literally, Your Honor, I'm doing my best. Are you telling me that your client was difficult, Owens? I'm doing my best, Your Honor. She's mad at me. Argument 3. The court erred when it denied a motion for new trial due to an emotional outburst. Let's see what you have to say. I am not very sympathetic to this argument. At all. Oh, thank you, Megalina. We'll have to find something comparable in the YouTube non-copyrighted music library. Oh, Law Nerds who were with me recording the podcast last night, it got copyright claimed. So if tomorrow's podcast is late, it's because we're going to have to run it through fighting over copy claim of footage of the Young Thug trial, because Billboard has decided that they own the trial footage. So we're going to have to fight with that before that goes live on Wednesday. I know. For court footage, it's so annoying. All right, let's continue on. Argument 3. The court erred when it denied a motion for new trial due to an emotional outburst. I would love to see how they describe this. Prior to jury deliberations, the alleged victim, the victim's family members began to audibly and visibly get upset and departed the courtroom. Undersigned counsel timely moved for a mistrial, requesting a new trial. He did do that. The court did not give any curative instructions or address whether the outburst could adversely affect the jury's deliberations. Florida appellate courts have held that the failure of the court to grant a curative instruction or a mistrial can result in the necessity of granting a new trial. Does anyone remember him asking for a curative instruction? I don't. The judge was just like, I didn't even hear what happened. And the person immediately left. But the defense did not request a curative instruction, and it was only after the break that they came back and said, I want a mistrial. Florida appellate courts have held that the failure to give that instruction can result in the granting of a new trial, and then they cite numerous cases. The court is unable to determine if the outburst affected the jury's decision because no inquiry was made. An inquiry being made, though, can Streisand affect the whole situation and actually make it worse. And they didn't ask. He didn't say, can you inquire of the jurors? He said, I want a mistrial, and then moved on. He didn't ask for a curative instruction. He didn't ask to inquire of the jurors. And the court's not going to inquire of the jurors generally in this circumstance unless the defense asks for it, because it can make it more obvious. It makes it seem more important than it is. Otherwise, it's like, oh, a human had a human response. Okay. I've seen jurors cry during trial. It can happen. Things are hard in court. Under controlling precedents, the defendant is entitled to a new trial. I mean, they barely even said what the case law said. This is slim on citing the law. It's like, here are the cases, but what do those cases say? Argument 4, the court erred in allowing the opinion of the state's expert not previously disclosed. I'm interested in this argument. The court said that they cured it. I think the appellate court will agree with the court, but we'll see. I don't think this was a great witness for the state either, though. The state's expert was kind of like a womp-womp. The trial court failed to disallow the opinion testimony of the state's rebuttal expert, Dr. Tanya Werner, after the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. I didn't love this expert. I don't think the testimony was clear, and I don't know. I think the court cured it. We'll see. The issue was discussed extensively in the expert witness's deposition taken on October 4th. The state committed prosecutorial misconduct by failing to disclose this new opinion as agreed in the why can't I say deposition? In the deposition mentioned above. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for the justifiable use of force and battered spouse syndrome testified to before the jury was improper. She barely even said that, though. Her testimony was so convoluted by sidebars that trying to parse what was actually testified to was actually fairly difficult. The state expert admitted she had not listened to the defendant's testimony before the jury when forming her opinion on this ultimate issue in fact, right? Which is why I think the jury was probably like, okay. I think the jury formed their opinion based on the video and based on Sarah Boone's own testimony, but that's just my opinion. The defense gets to argue what they want to argue. The state's expert testimony on the issue of whether the defendant perceived an imminent threat at the time of the event violates the provenance of the jury. And they did argue this at the time. I think this is fair to argue, but the court and the prosecution both said this is something that you have put at issue with battered spouse syndrome. And I'm just going to summarize it. Apologies if you all already get this. If somebody new is watching this, then I want to make clear why this argument is here and why this came in. Because oftentimes it's true, an expert can't come in and testify to an ultimate fact, but oftentimes they can. We're going to talk about Karen Reed in a bit. In the Karen Reed case, you saw experts coming in saying, hey, this victim was not hit by a car. That's an ultimate fact in the case, but it's also within the proper purview of expert testimony. In this case, the defense put that at issue. The defense was arguing self-defense. And as part of that self-defense, they were arguing that Sarah Boone's perception of threat of harm was seen through the lens of somebody who suffers from essentially PTSD due to being in an abusive relationship. And so the defense was trying to argue that when you look at how Sarah Boone perceived the threat, because in self-defense, it's what a reasonable person would have perceived in the situation, there was an asterisk to reasonable person, and that asterisk was a reasonable person who had been in an abusive relationship and had suffered from the impacts of that relationship so that their perception of danger is different than a person who had never been in that circumstance. So they were trying to argue that Sarah Boone's perception, the lens she sees things through, is shifted, and therefore the jury needs to look through reasonable with that shift. So that's the goal, is to look at reasonable through the shift. But that allows the prosecution to come in and say, okay, but she was not acting that way on this day, so we don't see the shift. So that's why they are talking about, did Sarah Boone seem to perceive the danger? I was kind of blown away that expert didn't watch her testimony. She was like, I don't have time. I was surprised she didn't watch Sarah Boone's conversation with law enforcement, because Sarah Boone's demeanor in that conversation with law enforcement, I thought, was instructive. And hearing words or seeing a transcript is much different than watching somebody say the things. So I was surprised that she was like, oh no, I just read the transcript of what she said. I don't know. If I was on the jury, I might have discounted this expert entirely and been like, okay, well, all right. Because I think what it would have mattered the most to me, chat, let me know what mattered the most to you in this case. I think what would have mattered the most to me is Sarah Boone's testimony, her interviews, the body cam footage, and all the videos. Like all this stuff outside of court. It's just on video. All right, I'm going to end the poll. Did you watch the Sarah Boone trial? Over 7,000 of you voted. 93 said yes. 7% said no. Hopefully the summary has helped. I would have just gone through, the videos and then seen if any of the rest of it helped. Because again, two things can be true at once. It says, furthermore, the state's expert testimony on the issue of whether the defendant perceived the imminent threat at the time of the event violates the province of the jury. I don't agree in this circumstance. Witnesses are prevented from expressing their conclusions. He argued this in court and it didn't go anywhere. When the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. Okay. When a witness is asked to express an opinion that applies to a legal standard to a set of facts, the opinion testimony is generally inadmissible. See what the court says there? Generally. Because sometimes it is. This is one of those times you put it at issue. I saw Lisa in the chat asked, Lisa, you are not timed out. We're just on slow mode. There's over 11,000 people. We're just on slow mode. We're just on slow mode. So if you remember on the channel, there's no slow mode, but we're just on slow mode. We're not on a very long slow mode. We're on a fairly short slow mode, but we're just on slow mode. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. I don't think she stated a legal opinion. I don't think she gave a legal conclusion. But this is an argument. This is the type of argument that goes up to the Court of Appeals. I don't think in this case it's going to fly, but these are the types of arguments on experts doing improper stuff that the court will take up. The court is going to deny that because this was extensively argued at trial. Argument 5. It's 2 sentences. Sir. Argument 5. The state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Counsel for the state made a second closing argument posed as a rebuttal. You could have asked ChatGPT to make that sentence longer, sir. Like, what? Sir. Even Grammarly is going to expand that sentence a little bit more. This is a I needed an extra page to my paper kind of an argument, but this is not it. Of the types of things that appellate courts will consider, and sometimes can get cases overturned, would be error in granting a continuance. I don't think that's going to be found here. I think this court is going to deny all of this. I'm not surprised. These things have already been extensively argued. There's nothing here that the court didn't listen to. The court listened to all of this. The court held numerous hearings on all of these things. But the stuff the Court of Appeals might be interested in when this gets denied and then gets appealed, like we're going to watch happen tomorrow. Tomorrow, we are going to watch oral arguments at the Supreme Judicial Court in Massachusetts, or listen if they're audio only. We'll find out together tomorrow. Emily, do you know? Nope. We're going to all learn together, but we're going to watch that tomorrow morning. It's the same type of arguments. The court denied it the first time. You asked the court to grant a new trial. The court denied it a second time. And you go to the appellate court, and oftentimes the appellate court also denies it. Are there interesting questions here? The interesting questions of law, on number 1, I think the court made a really thorough record about yeeting court-appointed counsel. Number 2, counsel was well advised about the continuance, that this trial was going come hell or high water. It had been 4 years. And I think what's going to count against counsel in the record is that Sarah Boone was also pushing the court to go to trial. Sarah Boone was very firm in, I want to go to trial. I want my trial. I want my trial. I want my trial. Number 3, the court failed in granting a new trial on the alleged emotional outburst. No. The opinion of the state's rebuttal expert witness, I think, is an interesting question. Of all the things of law that were argued, I think there's room to argue. I don't think it's going to be persuasive here, but that is a legal argument you can make. And then the last one was thrown in like spaghetti that's not going to go anywhere, because that was a great rebuttal argument, and he's being salty about that. The state should be flattered. But the state's rebuttal, a rebuttal doesn't have to be bad. A rebuttal doesn't have to be the defense said this, then this. It has to address what the defense said in closing. And the defense closing was so circuitous and wandering that there was nothing in the rebuttal that I'm like, the defense didn't even bring that up. The defense brought all of it up. None of this is going to grant a new trial. And even when it gets appealed, none of this, I think, will be appellate, will be reversible error. I think there might be conversation about experts, maybe, but that's it. So I don't think this is going to get very far. I'm interested to see what the state says. What the state's going to say is, wah, blah, blah, you knew and you were advised. I think we need an entire stream of going through the pretrial stuff with this to take a look at all of it. And the state will respond. This was just filed yesterday. We'll get a response from the state. The real question for me is not, will the state respond? The real question for me is not, will this be granted? It won't. The real question for me is, will Sarah Boone also file a letter regarding to this? That's my real question, is will Sarah Boone start to chime in on all of this? Let me see if anything's been filed this morning since we started streaming. Emily, why are we talking in the royal we? Because it's not just me, it's the law nerds. Like, we are doing this together. All of us are running away and talking about other things today because that's what we're doing. All right, let's see if anything else got filed today, just out of curiosity. Let's see. Nope, just the motion for new trial. The sentencing is still set for December 2nd, 2024, but I will be keeping an eye on this. If anything new gets filed, I'll let you know in the app first. But we're gonna keep an eye on this, and then we'll go from there. Let's move on. We have lots in the Karen Reed case to talk about. We've learned some new things. We're going to go to new things first. We're going to go to a summary. For those of you asking, is tomorrow related to Karen Reed? Yes. Tomorrow is the oral argument before the Supreme Judicial Court of Massachusetts. The court confirmed for me in email this morning that it will be streamed and that I am welcome to stream it. So thank you to the court, and I will be covering it. Will it be video or just audio? I don't know. I suspect it will be video, but we will see. So we're going to do that tomorrow. But for now, we're going to dive in. Oh, I forgot to do a summary. You're right, Miguelina. I forgot to do a summary. Hold on. Let's do a summary. For all of you that love the Quick Bits channel, this is where those come from. So thank you all that have subscribed to the Quick Bits channel. For those of you that are like, Emily, what are you talking about? I do have a second channel for when you're trying to stay in the loop, but like you also have life shit to do. And so we'll put a link down below, but if you want to go subscribe, the Quick Bits channel is moving towards 200,000 subscribers. And that is, here, I'll show you real quick, this channel. So it has a new channel bumper and everything. This is the Quick Bits. This is my channel. Somebody asked yesterday, is this really Emily's channel? Yes, this is really Emily's channel. We put up a new episode on Mondays. Mondays episodes have been teetering around 30 minutes, which is shorter than a live stream. And those are 30 minutes summaries of multiple stories that are going on, keeping us in the loop with everything. And we also do summaries of what I cover in the live stream, truncated. Those are shorter episodes. And then we also do day-by-day trial summaries. For those of you that like to listen in the background, these are also up on the audio feed of the Emily Show podcast. So if you go to the Emily Show podcast audio feed, wherever you audio feed, those are up there as well. And then if you ever want just the playlist of the summaries, that's on the Quick Bits playlist. So this is the Quick Bits channel. If you want to subscribe to Quick Bits, go subscribe. That is there. And if you like to listen on audio, it is all under the Emily Show podcast show. Those all go up there. So that is there. I know I still owe you guys more on the legal ASMR channel. Don't worry, it's coming eventually. It's one of those things that I'm like, I owe you guys videos. We joked about it. I owe you videos. There are more. There will be more coming. We will do more. They're more, less ASMR, more like legal sleep stories. That is the goal with that channel. So let us go to a summary, and then we will move over and talk about physically. Talk about the Karen Reed case. You ready? All right. So defense attorney Owens for Sarah Boone has filed a motion for new trial on essentially the same grounds that we saw throughout the trial, saying that, let me pull this up real quick, saying that the court erred in ruling that the defendant was not entitled to court-appointed counsel when more than 7 court-appointed counsels got yeeted off of the case by their own motion. They were like, please let me out. And Sarah Boone was forced to represent herself before James Owens parachuted into this case by choice. They say that the court erred in denying counsel's multiple motions for continuance. I think the court was pretty clear on that when we were watching the pretrial motions, saying if you come into this case, you are accepting the trial date as is. You knew when you chose the case. And then when Owens was complaining about not getting a continuance, he also complained that he doesn't live in Orlando. It's not like that's new information to you, sir. Then they're saying the court erred in failing to grant a new trial when one of the individuals in the audience had an emotional outburst in open court. Notice in this motion, he never talks about what that quote unquote outburst was. It was not something that was so great we heard it on the live feed from court. It's not something that seemed to cause a tremendous disruption. Someone seemed to have an emotional response to a video and then left the courtroom. But he asked for a mistrial. The court did not grant it. The court called it a minor disruption. And he did not ask that the jury be inquired about or inquired as to whether or not that impacted them. He didn't ask for that to my memory. And he didn't ask that there be a special jury instruction that they're to disregard that, though I think the jury instructions very well cover, and the jury instructions in Florida I found more clear than those in Massachusetts. The jury instructions well covered. You're not to base your verdict on sympathy for any one side, on empathy for any one side. It's to be based on whether this law meets what happened here. I thought those instructions were quite clear. He also said that the court failed to disallow the opinion testimony of the state's rebuttal expert. We heard lots of this argument that day in record. That testimony was probably 4 minutes of testimony and 4 hours of sidebars. That's minimal hyperbole because I don't even remember what actually was testified to because every other sentence there was a sidebar. And then he said that the state committed prosecutorial misconduct by making a second closing argument instead of a rebuttal. So the defense is also salty that the state's rebuttal argument slapped. That was a proper rebuttal. The rebuttal argument is to rebut what the defense said. And I think that in the rebuttal, the state did that. You've got to let me know, though, if you think that the state's rebuttal went outside the scope of what was in the defense. But a rebuttal doesn't have to be boring. It doesn't have to be an attorney with a notepad. In fact, I hate watching these rebuttals where it's like the defense said this and then this, the defense said this and then this. The rebuttal was fluid. The rebuttal talked about the suitcase, talked about how Sarah Boone may or may not have hit him in the suitcase, talked about the emotional aspects of the case, and then said, I'm not going to belabor it. Your dinner's waiting in the back. I thought the rebuttal was impactful. I thought it was concise. And the defense's closing was wandering and hard to follow. And numerous times during Owen's closing, he kind of gave the, you guys, I'm trying my best. So help me out here. And that's what this motion feels like to the court. Your Honor, I'm doing my best here, Your Honor. So help me out. He does say that he was not as prepared as he would like to be in this complex trial. But again, that was Owen's choice. So Sarah Boone's currently set to be sentenced December 2nd, 2024. We will see if this comes to hearing before that. If it does, I'll be streaming it because you want to watch it. I want to watch it. I want to see Judge K say no again because he said no on all of these. And this is coming before Judge K, this motion for new trial, which is typical after a conviction. Judge K is going to deny it. Then an attorney might choose to appeal it. But at the end of trial, we saw Owen say he was not going to be appellate counsel. So once this is denied and Sarah Boone sentenced, Owens will be off the case, and then appellate counsel will be appointed from whatever branch of the public defender's office locally handles the appeals, and Sarah Boone will have an appellate attorney. The real question here is, does Sarah Boone also write a letter to the court about this motion for new trial? That's really what I want to see, because this motion's going to get denied. Let's go talk about not Sarah Boone. We're done with Sarah Boone. Sarah Boone yeeted. Sit down. We're going to go talk about Karen Reed. Sarah Boone from not being able to afford any of the attorneys to Karen Reed affording all of the attorneys. Let's give a quick summary of what's going on in the Karen Reed case. Okay. Since the jury came back undecided in the Karen Reed trial, it seems that numerous jurors have reached out to the attorneys in this case, both defense and prosecution, to say, hey, we actually reached verdicts on 2 of the 3 counts. Was anybody ever going to ask us about that? Because we were only hung on the one case, on the 1 count, and nobody ever asked us about it. The defense made a motion to dismiss counts 1 and 3 because of the information from the jury. That was kind of a Hail Mary. I don't even think the law will allow for that after declaring of a mistrial. However, they also asked to be allowed to inquire into the jury, and they are making an argument that this violates double jeopardy, because it's really the only argument they can make. They can't make an argument for new trial because she's already getting a new trial. What they want is a new trial only on count 2, because that gets rid of some of the most serious counts in this case. And the double jeopardy, why can't I say jeopardy? The double jeopardy argument is an outside argument, but this fact scenario is incredibly unique. All of this could have been resolved if the court had polled the jury. The court didn't poll the jury. The defense didn't ask to poll the jury. And now here we are with jurors who sat for 6-7 weeks plus jury selection and said, but we actually came to verdicts and nobody asked us about them. And I think that the jury instructions are confusing on this. So I understand where there's room for confusion. The Commonwealth is saying, no, the jury notes were incredibly clear, and not a single one of these jury notes said we have reached verdicts on some counts. And it's a good point. It's a good point. The jury never said we've reached some verdicts and we don't know what to do, which makes this an incredibly unique situation. So the defense brought a motion to dismiss before the sitting trial judge, Judge Cannoni. Judge Cannoni denied it. The defense appealed it. And on Wednesday, November 6th, the defense is having oral argument before the Supreme Judicial Court in Massachusetts, before a panel of judges. I will be covering it here on live stream bright and early Wednesday morning. We're just going to go to court. I think we're going to have a pajama party and go to court together at, 8 a.m. Central. Look, it's a time change week. I literally think pajamas are what need to happen. Chat, I think y'all are like, yeah. So with all of it, we have had the briefing from the defense, which are along the same arguments that we've seen in their motions to the judge. Your Honor, the jurors reached out. They said that they reached verdicts. We never polled them. We should be allowed to ask. The state is saying they never indicated they had verdicts. Too late, too bad, so sad. We're going forward on a retrial. The ACLU jumped in and said, actually, we do have some concerns about whether or not this violates her right against double jeopardy, where they've actually acquitted her, but never put it on a verdict sheet. And the rebuttal from, or the rebuttal from the defense has remained, we should be able to ask the juries and the court should dismiss the 2 counts. I'm interested most to see what the judges say tomorrow and if they ask questions, because I think what the defense ultimately wants here is to be able to just inquire and go from there. Just let us ask all of the jurors. let us ask. Let us ask all 12 jurors. This is not unusual at this point. It has happened in multiple cases that we've covered where the jurors have been inquired from, did you reach a verdict? But you can't ask them, then why didn't you say anything? And that's the push-pull of this case. It's an incredibly unique and rare problem that, again, if the jury had just been polled, one person might have said, hey, what about those counts that we reached a verdict on? And the court could have said then, if you have reached any verdicts, go put it on a verdict form. But no, the court doesn't have jurisdiction to redo what the jury did. I don't know if there's a legal remedy here. I really don't. I'm interested to see what the court questions are tomorrow. But since that time, there has also now been yesterday, I was waiting for this. Yesterday, there was a joint motion to continue. Now, there's been joint motions to continue before that the court has denied. I don't think this one will be denied. I think it will be granted. There's a joint motion to continue, but we learned some new information, so we're going to go over that. There are updates in the civil litigation that I covered from the victim John O'Keefe's family suing numerous bars and Karen Reed for wrongful death and other things. We went over all of that in the breakdown of that suit. So we're going to update on what's going on there as well. So those are our, let me make sure we don't have any other topics that I intended to cover. I don't know if we're going to get to the Vanity Fair articles. I have not read them. Y'all have asked me what I think about them. I don't know. We'll see. Maybe we'll get to that a different day. Maybe we'll get to that in members only. I don't know if we need to go through all of them. Do we learn anything new, chat? We'll see where we're at when we cover all the rest of it, and then maybe go from there. We'll just see what time allows for, right? First, we're going to go for that. First, we're going to get into the motion for continuance because we learn some new stuff in there. And then we'll do just one more summary of the defense's argument because we didn't go through the defense reply yet. But it's going to be what we already saw. Like, we're going to get a lot of repetition because we've now seen these arguments like 4 or 5 times. So it's not going to be too much that's new. But this motion for continuance is new. So we're going to do that first. Let's see. Where is the filing? I saw this yesterday afternoon on Ted Daniels' Twitter. I don't use X, but I definitely keep an eye on what a few people post about the cases that I'm covering because it seems to go there first. So that is the only way I use it. Do I post there? No. If I'm inclined to post anything, it just goes into the Lawnerd app at this point, to be honest. Why? Because we build our own app. So that's where I choose to spend my time. All right. Also, I don't like being inundated with stuff. Everything feels overwhelming. So I try to limit where I spend my time so everything doesn't feel overwhelming. Let's take a look at this joint motion to continue the trial date. This was filed yesterday afternoon at 3:00 Eastern. So let us go. Commonwealth and defense joint motion to continue trial date. Are we surprised? Is anyone surprised by this? The case is scheduled for trial January 27th, 2025. The Commonwealth and defense are jointly requesting a continuance of the trial date until April 1st, 2025. Could you pick anything other than April Fool's Day? No, April Fool's Day is what we're doing. But we've seen numerous requests for continuance, in this case denied by the court. I wonder if this will be. I think she'll grant it. There's a new prosecutor or a new lead prosecutor. I think she'll grant it. But really, April 1st? And if this goes on April 1st, it's going to bump right into Corey Richens. What are we going to do? Trial dates aren't always fixed. We'll see what happens. The joint request will allow both the Commonwealth and defense adequate time to prepare for trial, accommodate the schedule of new witnesses, including expert witnesses, and will allow for the testing and disclosure by the experts timely before trial, and will result in a far more efficient and streamlined presentation of evidence by both parties. Streamline, you say. Efficient, you say. How many witnesses are we going to ask about high top tables if it was snowing and where they were sitting at the basketball game? Because we definitely could have streamlined this before. The Commonwealth has recently filed a notice of its intention to retest forensic evidence. Further, the Commonwealth has provided notice to the defense that it has retained a biomechanical engineer who is expected to testify at trial. Now there's a biomechanical engineer. How is that really? What are you retesting? And did you find a biomechanical engineer that's going to go up against the biomechanical engineers who already testified? Because they were pretty neutral and great. So they were pretty neutral and great. Chat, I don't think we're going to see Trooper Paul. I don't think we're going to see Trooper Paul. I don't. Okay. The Commonwealth's biomechanical engineer cannot provide a report to the defense until the forensic testing has been completed. Are they going to try to forensically retest the car? Because we know there was a lot of information they didn't get out of the car. And the dude who pulled the information out of the car was like, oh yeah, I couldn't get that. Like, we got some of this information, but there was other information we just couldn't get. Do they have it now? Moreover, the Commonwealth has provided notice of additional experts who did not testify at the first trial. How many new experts are there? And intends to retain additional experts beyond those. Who? And for what? They're like, we've got, Your Honor, new trial, who this? We've got all new witnesses. We're yeeting all the old ones. That didn't go so well. We're going to get rid of all those old experts. And we've got new people. All new people. They are saying these new Commonwealth experts are expected to generate reports following testing and analysis, which the defense will need time to consider and potentially respond to, possibly with additional experts of its own. So less civilians, more experts. The Commonwealth will be filing a Rule 17 request and motions in limine, and at least one Lanigan hearing for one of the defense's potential witnesses. Your Honor, we have a lot of pretrial shit to do, and we're not going to do it over Christmas. The Commonwealth also expects to file a motion for reciprocal discovery and defense expert disclosures. It's a whole new world, Your Honor. All new witnesses, whole new trial. Oh boy. It's expected that this evidence will be relevant and material to the Commonwealth and, of course, will need to be provided to the defense in order for the defendant to adequately be prepared for this trial. The Commonwealth is doing everything in its power to be as expeditious as possible to properly prepare for this trial and ensure the defendant is given a fair trial. The parties jointly believe that additional time is necessary in order for both sides to prepare for trial and litigate any additional matters prior to trial. Yeah, they're going to need to do a lot of that. And therefore provide a more efficient, streamlined, and shorter presentation to the jury. Your Honor, I swear if you give us more time, we'll do it better. We'll do it. We've got this time. Take two, Your Honor. A whole new presentation. It won't be as long of a trial. We swear. Please give us a continuance. And that is Special Assistant District Attorney Hank Brennan. Notice nobody else has signed on this. And of course, Alan Jackson and David Yannetti. And then we've got an affidavit from the new appointed special prosecutor. Okay. On September 17th, I was sworn in as special prosecutor to represent the Commonwealth in the trial of Commonwealth versus Karen Reed. Well, the retrial. On October 11th, I filed notice of appearance to the court. Why did it take you so long? On October 11th, I filed the Commonwealth's notice of discovery with the court and provided notice of discovery to the defense. Discovery notice that included but was not limited to a copy of updated Celebrite report of web history. What? A new Celebrite report with updated report of web history? Can we guess whose web history it is? The how's long of it all. Again? A copy of the CV of Judson B. Welcher, PhD, and the CV of Hannah Knowles. On October 11th, I filed a notice of scheduling, reassembly, and testing of defendant's Lexus telematics systems. Oh, they're going to try to get the info out of the car's black box again. Remember how disappointed I was? Were y'all with me when they were going through the black box of the car and the guy was like, yeah, we don't know how to get that out of the Lexus. What? They were just like, we couldn't figure it out. So it looks like they're trying to get more information out of the car. So they are going to reassemble and test the telematics systems of the car. They requested a 14-day hearing date. The defense requested the date of November 13th, and the Commonwealth agreed. Great. Put it on the calendar, November 13th. Let's go. On October 18th, I filed the Commonwealth's motion for records from Verizon and the motion for records from Boston 25. What'd you want for Boston 25? Any guesses? Undersigned counsel is in the process of reviewing and indexing discovery. Counsel has retained several new experts for trial and expects to hire more. With whose money? Undersigned counsel intends to file Rule 17 motions in limine, file for a Lanigan hearing relative to one of the defense's potential experts. Counsel intends to file a Rule 17 motion relative to 2 accident reconstruction experts called by the defense at the first trial. What is your issue with Crash Daddy? Okay. I've spoken with the defense. It is agreed that a continuance is necessary for both parties to adequately prepare for trial. They're just like, we're going to reinvestigate the whole case. This is the whole case. A continuance will allow the Commonwealth to retain, consult, and disclose all expert materials and to the defense, and further allow the defense to consider additional experts. So the defense is going to spend more money on this. The Commonwealth is going to spend more money on this. Oh, goody. What is the notice of discovery? Let's see what they're turning over. Oh, maybe this will maybe give us, keep reading, Emily. This will give us some more introspection. Copy of bills from grand jury of March 2024, 24 pages. Okay. More stuff from the grand jury, the results of which we have not seen yet. Copy of transcript of Karen Reed's interview with Boston Magazine's Gretchen Voss on June 20th, 2023, 202 pages, including word index. Oh, okay. Copy of transcript of Karen Reed's interview with Boston Magazine's Gretchen Voss on July 13th, 17 pages. Copy of transcript of Karen Reed's interview with 2020, 90 pages, including word index. Copy of Trooper Paul's supplemental collision analysis and reconstruction report dated July 24th, 2024. Really? More from Trooper Paul? Really? Copy of photos from Trooper Paul's supplemental collision analysis and reconstruction report dated July 24th, 140 photos. Copy of video from Trooper Paul's supplemental collision analysis and reconstruction report dated July 24th. Copy of internal investigation report on Lieutenant Fanning dated July 15th. Email from Daniel Linden dated October 25th. Copy of supplemental report of Shannon Burgess, 2 pages, October 17th, 2024. So they are retesting, it seems, and rethinking their entire trial strategy, which means this retrial, when it goes to trial, if it goes to trial, might contain quite a lot of different evidence than we saw at the first trial. Oftentimes, retrials are a shift in strategy. This seems like a very large shift in strategy, which is probably why the DA's office brought in a new DA to look at things differently. They're like, all right, we need someone else to look at this. So we're bringing in someone else to look at this. Oh boy. And quite a lot, it seems, of new experts. And yes, they are allowed to bring in new experts. They are allowed to retest evidence. They are allowed to rework their theory of the case. But it again, they've seen the whole defense case, and now they get to say, okay, we've seen all of this come out in trial, and now we get to rewrite our offense and shift the way we test the case or shift the way we try the case. Oh boy. This is going to be a lot. This is also going to be expensive for everyone involved. So, residents of Massachusetts, that's a lot. And these are things that could have been done that weren't done. I wonder if the state's overconfidence might have been an issue at the first trial. If the prosecutor, and I'm not saying this is true, if the prosecutor is like, oh, I see the case this way, everyone will see it that way. It's clear that everyone did not see it that way. They have a lot more information now on how this case might have been viewed. I don't know how many people stream this trial talking about it. They have all of that input. They have the input of everything around the internet. I don't know if Lally wants all that input, but you have a lot of input aside from the jury of how people saw this case and where people took issue, critique, or criticism with how the evidence came in, what the evidence showed, how people testified, and they can take all that feedback and shift their trial strategy. And that's wild. Rochelle Chavez in the chat said, can they reference new trial in the retrial? Not really. It would generally, or should generally be, at a previous court proceeding, did you testify to this, this, or that? That's how it should be. So we'll see. All right. We've got more to get through on the Karen Reed case. So let's see what else. I was surprised. Tracy said more Trooper Paul. Lol. I'm surprised that there is more Trooper Paul. Jake B said, what about the FBI investigation? No idea. No idea about the FBI investigation because there's been no result of the grand jury. So we don't know yet. We just don't know. So we will see. But there are a few more things we need to go through, and then we will summarize all of them. Let's see. We've got to go to the civil case. Let's do that next. And then we'll take a look at anything else before tomorrow that we need to cover. But the case ruled in the wrongful death lawsuit, and we're going to go to that now that this is from Halloween. So let's cover that ruling. I'm not surprised by this ruling. I've covered the wrongful death case. Here, we will link it. If you're watching this on replay, we'll link it down below so you have it. And we will go through what the court ruled. But essentially, Karen Reed had asked to delay anything going on as to her with the civil case until the criminal proceedings were done. And the court is saying, yes, that's not a surprise. You can't really give a fair and honest deposition while you still have the right against self-incrimination. Otherwise, you go to deposition and say, I'm not answering that. And then the entire deposition is, I'm not answering that. It doesn't make sense to even run a deposition when somebody still has Fifth Amendment rights pending. It just doesn't make a ton of sense. So this is in the Paul O'Keefe estate and personal representative versus C.F. McCarthy's Karen Reed and the Waterfall memorandum of decision. So this is from the judge from Halloween. Memorandum of decision and order on defendant Karen Reed's motion to stay civil proceedings pending resolution of criminal trial Defendant Waterfall Bar and Grill's motion to stay pending resolution of related criminal trial, and defendant C.F. McCarthy's motion to stay. So all the parties are saying, hey, can we wait until the criminal shit's done? Can we just wait? All right. The estate and some surviving relatives of John O'Keefe filed this action against C.F. McCarthy's, The Waterfall, and Karen Reed, alleging wrongful death, negligent, and reckless infliction of emotional distress. For the reasons discussed below, defendant's motion to stay the proceedings pending the resolution of the criminal trial against defendant Karen Reed are allowed in part and denied in part. Background. Plaintiffs filed this action on August 26, 2024. We covered the action below. Their complaint alleges the following facts: that C.F. McCarthy's is a bar, that the Waterfall is a bar, that Karen Reed was dating John O'Keefe. On January 28, 2022, Reed arrived at C.F. McCarthy's around 8:51. Between 8:58 and 10:29, the restaurant served her 7 alcoholic beverages, which she drank. Reed, who showed signs of intoxication while at C.F. McCarthy's, left around 10:40 p.m. carrying a beverage out of the restaurant. Remember, this is what's alleged in the civil lawsuit, and the judge is just running down, this is what's alleged in the civil lawsuit. That's it. This is not saying that the judge agrees. This is not saying that the judge disagrees. This is just saying what is alleged in the civil lawsuit is this. So just as we are clear, I know some of you are going to say like, but what? This is what's alleged in the civil lawsuit. It goes on to say that Reed and O'Keefe entered the Waterfall Bar and Grill around 10:54. Reed carried in a beverage from C.F. McCarthy's and showed signs of intoxication. Between 10:54 and 11:54, the Waterfall served Reed 1 shot and 1 mixed beverage, which she drank. Again, this is what's alleged in the civil case. Reed and O'Keefe left the Waterfall around 12:10 on January 29, 2022. Plaintiff's complaint alleges the following additional facts. Reed was under the influence of alcohol, unable to safely operate a motor vehicle. It was snowing. Everyone in the chat who was asking, there you go. It was snowing, and there was an impending blizzard. Reed drove O'Keefe to the residence at 34 Fairview in Canton. After O'Keefe exited the vehicle, Reed drove her SUV into O'Keefe, knocking him to the ground and causing him serious injuries. Reed then fled the scene and returned to O'Keefe's residence at 1 Meadows Ave in Canton, leaving O'Keefe on the ground in a blizzard. O'Keefe died from his traumatic injuries and hypothermia at 7:50 a.m. on January 29th. Reed's blood was drawn that day and read 93 milligrams per DL liters, I think, which extrapolates to a BAC of between 0.13 and 0.29 at the time she hit John O'Keefe. Counts. Travis, you scared the shit out of me.
Sorry, I was just listening for a sec.
My light is red. You know that I'm streaming. What?
I was just checking on you for a second. I'm sorry.
What do you need, my son?
I was going to share a funny story, but then I realized you're streaming, and I listened for a second.
Can you just check YouTube before you come down here to share a funny story? We can go through internet memes later.
No, it's sorry about that, but no. You carry on.
Thank you for allowing me to carry on.
YouTube's too much work. I can just walk it out.
You said checking on YouTube's too much work.
Yeah, I can just walk down the stairs.
The light outside, the recording light on the studio is red. And now my face is also red.
I just want to see what you're talking about.
We're talking about the Karen Reed case and her civil case.
I just thought it was funny. Dad was trying to get audio on YouTube, and he had it muted, and he's like, why is there no audio? So I just unmuted for him, and he's like, oh.
Well, thank you for unmuting YouTube for Dad. Is he watching me?
No, he's trying to.
Of course he's not. Okay, go out. Out. The funny story was my husband boomering YouTube is I think what Travis was trying to tell me. And then he realized I was streaming when he could have just checked YouTube in the first place. But my son does not have school today because a lot of the schools in our area are polling places. So there's no school because the schools are quite busy with being polling places. He scared the ever-living shit out of me. If y'all wonder how jumpy I am, that level of jumpy, it's just look, there is no controlling that level of startle response. Apologies if I scared any of you. I scared me. Okay. Oh, teenagers. All right. Let us continue. All right. Lord. I know. Code Travis. He's like, I didn't realize you were streaming. Literally, the light outside my office is red. I'm going to sue him for emotional distress of having a teenager. Yes, in the words of MCR, this teenager literally scared the living shit out of me. All right, let's get back to CF McCarthy's. For I need a drink. All right. Counts 1 and 3 of the complaint allege wrongful death against CF McCarthy's in the Waterfall and Reed, respectively. Counts 4 and 5 and 8? What? I don't. These ones. My brain has stopped with the Roman numerals. Alleged negligent, reckless, and intentional infliction of emotional distress. In connection with O'Keefe's death, Reed has been charged in the Norfolk Superior Court with second-degree murder, manslaughter while operating under the influence, and leaving the scene of an accident, causing death. Following the criminal trial that ended in a hung jury on July 1st, Reed is scheduled to be retried on January 27th, 2025. I mean, for the moment, it's going to change. In the civil case, Reed has not answered the complaint. Instead, she moved to stay the proceedings. According to the tracking order, discovery will not close until August 17th, 2026, and no trial date or pretrial conference has been scheduled. The plaintiffs have noticed the deposition for December 4th. Right, here's the issue. You can't take a depo until she is out of appellate rights because she cannot be forced to testify against herself. And all of these facts stem from the same incident the criminal case does. So you can't depose somebody and then have that out there that can be used against them in the criminal case. She has a Fifth Amendment right. So I'm not surprised that the court's like, yeah, we're putting a pause on this. Reed moves to stay this action on the ground that her Fifth Amendment privilege against self-incrimination would be impacted if the wrongful death case proceeds while the criminal prosecution's ongoing. That's legally sound. The bars also moved to stay this litigation to preserve the resources of the parties and witnesses and promote judicial economy. They're like, why would we move forward on this case until all the defendants move forward on this case? Because what the bars are going to say is it's not on us, it's on her. And the witnesses in the criminal case said none of them thought that Karen Reed was intoxicated. The bars want to rely on that too. The bars are going to say, look, everyone said she was fine. How were we to perceive that she was intoxicated when her friends thought she wasn't intoxicated? They say a stay of proceedings in a civil case pending the resolution of parallel proceeding is addressed in the court's sound discretion. So the court gets to choose. And the court needs to give consideration to the rights of the defendant here and judicial economy in the civil case. It goes on, or the judge goes on to say, participation in the civil case poses the danger to the defendant of an increased likelihood of conviction at the criminal trial by self-incrimination through exposure to cross-examination. Despite the strategic dilemma posed by parallel proceedings, the refusal to stay a civil case pending the outcome of a criminal prosecution does not violate due process, even where the defendant's refusal to testify in the civil case creates an adverse inference to her, which is interesting. In deciding whether to enter the stay, the court must balance the compelling interest at stake based on the particular facts of the case, the interest of the public, and the parties. They say the estate undoubtedly has an interest in the expeditious resolution of the wrongful death case. Nevertheless, Reed's criminal retrial is scheduled to commence January 27th, and based on the first trial, will likely take no more than 3 months. A stay of 6 months is reasonable and would neither violate the public interest nor, as discussed below, unduly prejudice the plaintiffs. Now, this is going to shift if that trial gets pushed back to April, because then it becomes a stay of more than a year. Let's see. The plaintiffs claim prejudice from a stay due to the degradation of evidence. Specifically, they argue the restaurant employees and third-party witnesses may experience fading memories or become uncooperative over time. Given the extensive investigation into O'Keefe's death and the completed first prosecution, the risk that evidence will become unpreserved and witnesses' memories fade does not appear to be substantial. These witnesses have already been talked to. These witnesses testified at trial. There are transcripts of what witnesses have said. The plaintiffs further contend that delay will be prejudicial because Reed's media campaign is poisoning the jury pool, citing her October 18th, 2024 televised interview with NBC's Dateline. The court goes on to say any influence on the jury pool from delay can be remedied by the usual procedures employed during impanelment to ensure that jurors remain impartial despite any prior knowledge of the case. Voir dire. We will do voir dire. Let's see. The judge goes on to say, moreover, because this case is in its earliest stages and the criminal case is scheduled to go to retrial in 3 months, the court said that a lot. The court said a lot of times this case is going to trial in January. And this case is probably not going to trial in January. They say because it's going to retrial in 3 months, the court will not be inconvenienced by a brief stay, and any scheduling conflict with witnesses that might arise would presumably be resolved in favor of the criminal prosecution. Even with a brief stay, the plaintiff's wrongful death claim can be litigated within the established tracking order. The bars emphasize that their employees and third-party witnesses who testified at the first criminal trial may be subject to discovery in this trial while also having to testify in the criminal retrial. And therefore, they urge a stay to preserve the resources of the parties and witnesses. However, defendants have not demonstrated an undue burden on the witnesses from parallel proceedings. If a bartender needs to come in and do a deposition, it's going to take a day. And the court is saying it can take a day. The court only gives minimal weight to the preservation of the parties' resources. The most important factor to be weighed is the potential impairment of Reed's Fifth Amendment privilege. Right. I'm sorry that if C.F. McCarthy's is inconvenienced by an employee being out a few days for trial and out a few days for deposition. That is inconvenient, but not as inconvenient as the Fifth Amendment right for Karen Reed. So the court's not super persuaded by that. However, depositions and discovery can happen. Karen Reed's deposition cannot. So some things can move forward and some things don't. They go on to say, although the restaurant's civil liability turns on whether they acted reasonably when serving alcoholic beverages to Reed prior to O'Keefe's death, their liability nonetheless depends on whether Reed hit O'Keefe with her vehicle. A critical issue in the criminal prosecution. The court's not wrong. There is thus substantial overlap between the two cases implicating Reed's Fifth Amendment privilege. Plaintiffs argue that, quote, by actively participating in public disclosure and potentially profiting from media engagements, they're pissed about the interviews. This was before the 2-part Vanity Fair interview. They say Reed effectively forgoes any claim of Fifth Amendment protection, and her choice to speak out starkly contradicts any suggestion that she is concerned with self-incrimination. The court said they're big mad. As distasteful as Reed's media campaign may be to the plaintiffs, her statements to the media about the criminal case do not constitute a waiver of her right against self-incrimination. The court's like, yeah, no. We get that you don't like it, but no. They say the court says the court must give due consideration to that weighty privilege. As noted, supra, the civil suit is only in the initial stages, whereas the criminal retrial is scheduled for January 27th and likely will not last more than 3 months. The prejudice to Reed from having to choose between defending this wrongful death action and protecting herself from providing evidence that may be used against her in a criminal retrial outweighs the estate's interest in the expeditious resolution of the wrongful death case. Thus, a brief stay of this action is warranted. Nonetheless, a general stay of litigation generally is not the best option available to the court and the litigants, and a stay should be tailored to avoid undue prejudice. By limiting the stay to the deferral of particular discovery, the court can allow civil proceedings to progress as much as possible without prejudicing the litigants' interests. It's unnecessary to completely stay the action to avoid impairing Reed's Fifth Amendment privilege. Rather, the interests of the parties, the court, and the public are best served by stating that only the discovery directly to Reed pending the resolution of the second criminal prosecution in Norfolk Superior Court, or to stay just that. I read that awkwardly. So the court's like, we can move forward, but not to Reed, and we're not going to hold it against the other defendants because this whole case hinges on, did Reed hit O'Keefe with her car? If Reed didn't hit O'Keefe with her car, then the restaurants aren't liable for over-serving her in a wrongful death because she didn't cause the death. So the court's like, look, all of this hinges on Reed's actions that have not yet been determined in criminal court, And she can't go to deposition while the criminal case is pending, but other discovery can move forward. The court said for the foregoing reasons, it's ordered the defendant Reed's motion to stay civil proceedings be allowed to the extent that the scheduled deposition of defendant Reed and other discovery from defendant Reed are stayed pending retrial. The other motions are denied. So discovery can go forward except as to Reed. I think that's a appropriate and tailored resolution from Judge William M. White. I'm disappointed that that's not William W. White. www. Justice of the Superior Court. So William White Jr., I think it's a measured response. Truly. I think that there's really, I don't know what the other option was here, but you can't go to deposition. I mean, I guess you could force somebody to deposition and they would have to not answer anything. And then it could de facto harm Karen Reed's case. And I don't think that's fair, right? That if you are looking to resolve a case and find out what happened, if the equitable resolution of a case is the desired outcome, this is a fair and measured approach. So you guys are like, I love WMW. Leah said WMW is a nice monogram, though. It is. It is a major monogram. It is a good monogram. So let's give a summary of those two, and then let me put up a poll. 2:50. All right. Let's see, what time is it? All right, chat. With over 10,000 of you in here, should we go through some of the Vanity Fair articles? I have not read them. Should we go through some of it? You let me know. Let's try to do a summary of those, and I'll let you guys vote. But it will limit our Q&A. We'll do a quick Q&A, but it will limit some of our Q&A. So in the motions today and the court order that we covered for Karen Reed, the discovery that is ongoing is the reason the defense and prosecution are asking that the criminal trial currently scheduled for January 27th, 2025 be continued until April 1st. No, I'm not joking, 2025. That includes the new prosecutor indicating that the state has multiple new experts, that they are trying to get new discovery out of Karen Reed's vehicle, that they are reassembling the technological components of Karen Reed's vehicle and trying to extract more information out of the Lexus's black box, which we heard in the first trial that they could not get to. They have done a new Celebrite report regarding computer searches or web searches. I wonder what Celebrite report they have rerun. They are bringing in new experts, including bringing in biomechanical engineers, and they anticipate more pretrial litigation with regard to the defense experts, the crash daddies, and their own new experts. So it seems that with the new prosecutor has come an entirely new trial strategy with a fleet of new witnesses. And it was noted in the motion from the prosecution and defense that the prosecution anticipates even more new experts. So the prosecution is completely reinvestigating this case, it seems. And then as far as the civil wrongful death case from John O'Keefe's estate, the court has agreed to stay the proceedings as to discovery from Karen Reed in consideration of her Fifth Amendment right against self-incrimination. She shouldn't be forced to a deposition. She shouldn't be forced to a deposition, the court said, when she is still pending a trial, though the court noted in that order, which was signed on October 31st, that the trial was going to be done in just a few months because it was starting in January. If this trial gets put over till April, I wonder if we will see the plaintiffs in that case, the estate, asking the court to reconsider this ruling, because the court mentioned in the ruling numerous times the case is going in January. It's only going to be a few months. No one is harmed by a delay of a few months. So the discovery is going to be stayed as to Karen Reed and can continue on as to others. And the court pointed out that the civil lawsuit really hinges on whether or not Karen Reed hit John O'Keefe with her car, which the court noted is the central issue of the criminal trial. And it is the central issue of the criminal trial. So with that, we have gone through the updates in the Karen Reed case. We will see what happens when that case goes to hearing at the Supreme Judicial Court. Just for expectation management, those judges are not going to rule from the bench. We're going to have to wait on a written order. They're going to hear oral argument, and then we will get a written order later. So we might not even have an order from the court on this hearing until after January anyway. So I'm not surprised that there's already a motion to continue. I will be very surprised if the court doesn't grant it, but this judge has surprised us before with not granting continuances, so we'll just have to see what happens, won't we? What I will note, asterisk, Emily, footnote to the footnote, addendum. I will note that the prosecutor, the new special prosecutor, did say at least 3 times that this continuance would help. Wait, I'm going to pull up the exact language. Where is it? Let's see. Where is it? I wanted their exact language. The prosecutor said multiple times that the parties believe additional time is necessary for both sides to prepare for trial and litigation and provide a more efficient, streamlined, and shorter presentation to the jury. So what that says to me is, Your Honor, I beg of you, please continue it, and we promise this trial won't go into the weeds. It'll be more streamlined. We'll do it better this time, Your Honor, I swear. So I think they're really trying to tell the judge, if you just give us this one continuance, we won't be here for weeks on end asking if it was snowing. Promise. So we'll see what the judge does. I'll be surprised if this continuance is not granted, and that means we're going to see the motion bounced to, or we're going to see the Karen Reed retrial bounced out until at least April 2025, though the court might say, hey, even if it doesn't go to April, the court might continue it to March. So we'll see what the court decides to do. And with that, I'm going to look at questions real quick, and then I'll look at the poll. Let's see. We'll do a few of our questions, a few of our super chats, and then we will see what the polls. 84% of you are like, let's go through some of the Vanity Fair. I don't know if we can. It's long. We're not going to be able to read it line by line. We'll zoom. Let's see. We got some of our super chats. Welcome to all our new members. Cindy Collins said, emotional support Canadian reporting for duty for our neighbors in the South. Thank you, Cindy. We're just doing a stream of other things today. So Sandra D said, hey, you guys, Lawnards, I know you're happy to be in Lawnard company today. So I appreciate all of you for being here. That's why we're streaming about all of the other stuff that's going on and having a, I think we decided we're having a pajama party tomorrow. I think we all just need it. Come cozy. We'll just do a cozy court stream. Why? Because we're going to hear the same arguments we've heard 7 times already. I don't think we'll hear anything new. If we hear something new, I'm going to be like, ooh, really? Angel said, good evening from Bulgaria. Food court is my favorite type. Cheers to 15 months as a member. I've heard that from a lot of you. A lot of you that are newer to the channel were like, wait, food court's a thing? I love this. It's needed after the heavy trials. We were woefully delayed in a food court, but food court, I love food court. Lauren C said, thanks for being here after surgery. It comfies. You are welcome very much, Lauren. We are here. Thank you. Miguelina created a food court playlist on the channel, so we have it. Also, Cass said, so excited. My tumblers and hoodie arrived today. Yay. Casey Cat said, can we circle back to Mr. Beast? I mean, I talked about him briefly on the Monday episode. There's not much new in the Amazon lawsuit that I've seen. So for me, there's not a ton to circle back to. Music to My Soul says, yay, here comes EDB to distract me from anxiety. I get it. It's a day for everybody. Kara said, hello, Lawnard, 6 more days until my 60th birthday. Kara, happy birthday. Miss Mandy Reacts asks, is Karen Reed's trial is delayed? Is this good news? I mean, I don't know if it's good news or bad news. It just is. The defense and prosecution agree. I think that it's probably necessary. I think a streamlined presentation of the evidence is good for everybody. Yes, the state can bring in new experts. I don't know if that's going to make their case better. at the end of the day, we're gonna see the same thing from all of the pathologists, and the pathologist testimony is pretty compelling to me. So we're gonna see the pathologist testimony. I don't know if we're ever gonna know what happened. That trial left us with a lot of questions and not a lot of answers for me. And I think when you get into that many questions, it brings doubt. The jury doesn't have to believe the defense theory of the case in this case to have doubt, in my opinion. They can look at the prosecution's case without all of the defense case and say, how did we get here? And even if you put on only the defense experts as to the biomechanical, you still get to, how did this happen? What happened to John O'Keefe? You take everything else out of it, that question was still not well answered. And I don't know if any delay is going to help. It's going to be frustrating for Karen Reed. They're going to spend a lot of money. Casey Cat said, Sherry Haynes in the chat has a son who works for Pokemon. Oh my God, I love Pokemon so much. We need all the tea. We do. They added new recipes in Pokemon Sleep. So now I'm trying to match all the recipes or get to all the recipes. Pokemon Sleep added coffee as an ingredient. I love all the Pokemon stuff. I don't know how to play Pokemon the card game. It was a bit out of my generation, and my kids are Yu-Gi-Oh players, so I understand that moderately, but math, though Griffin can do math in his head like a rock star. I don't understand it. He tries to explain. But they play Yu-Gi-Oh, not Pokemon the card game. But I love the Nintendo games, like the OG games, and I also love Pokemon Go. But I have deep sentimental attachment to Pokemon Go because it came out right as I was recovering from a spinal fusion. And all I could really do most of the time was walk at like a shuffle. And so it gave me something to do while I was walking and didn't make me feel quite so frail. But spinal fusion was a hard recovery. And it kept me from not feeling angry about the fact that I was recovering. But I was frustrated. But recovering from surgery and injury can be frustrating. There's a huge emotional and mental component to it. Armchair Lawyer said, can we cover Boone prison behavior reports lots of negative points earned? Are we surprised that Sarah Boone's like, if you just put me in charge, I could do it better? I don't know where those are. If somebody emails them to me, I'll take a look. Tien said, dog and sky exploding fireworks, EDB plus really loud music. Okay. I saw a couple of you mention fireworks in the chat. Bring on the Boone. Thank you for body doubling with me on streams. I know, excuse me. I know a lot of you use the streams for that. So I'm here for it. Excuse me. My voice just decided to be a problem. I'm here for it. That's what we're here for. Sabrina said, not intentionally. Sarah Boone's like, Your Honor, you just don't understand. Sonia said Sarah was definitely happy with the way the trial was going. She was, until she wasn't. Stephen said the text, her video, and the body cam footage was damning for me, but the prosecution hitting the suitcase with the bat sealed the deal. It was a good demonstration. Real good demonstration. Oh, Katie in the chat, thank you. Katie said, Emily, it's Guy Fawkes Day in the UK. Fireworks are normal there today. So bonfire night, firework night in the UK. All of our UK law nerds enjoy the firework night. That sounds fun, but also fireworks, I get it, definitely terrifying to the paw nerds. So thank you, law nerds. I was like, wait a second. It's like 1 o'clock in the afternoon. International, I get it. Let's see. Sassy Footnote said, my favorite blobbity blobbity. Yeah, at some point we're like, blah, blah, blah. Look, for all of you that saw my Pop Socket haul last night as I was recording the podcast, I'm not done with spooky season just yet. I feel like the Sarah Boone trial delayed my spooky season. So my spooky season's just going to go the rest of the month. I'm leaning in. Enchanted Wolf said, I actually crafting a chat got closing for Sarah Boone. Thank her own lawyer had. I think that got auto-corrected, and I am sorry that I did not interpret it well. So thank you. Let's see. Casey Cat, thank you for the gifted memberships. Just Gary said, but Emily, was it snowing? I'm still a bit confused. Me too. I don't know how much snow. I don't know enough about the tables. Amster said, have you read the bedrow letters? No, I haven't. That's connected to Karen Reed. I haven't. Apple Jam said, no, I cannot do Karen Reed in April. My baby boy is due the 15th. I can't handle listening to Lally while I'm in labor. Lally will not be asking most of the questions. I don't know if that helps Apple Jammin', but it won't be Lally. It'll be the new prosecutor. Vicky said, who will Karen Reed's lawyer be at the hearing tomorrow? It will be the lawyer that we heard on this motion. The last time this motion was before the court. So it will not be Jackson and the other one. It'll be her appellate lawyer, whose name has escaped me and I don't have the document up in front of me. Annie said, wasn't the telematics system destroyed? They said it was taken apart, but apparently now they're trying to put it together. How convenient. We'll see if that works. Music to My Soul asks, so a retrial allows them to bring in new evidence and experts. Why? Well, they can choose how to present their case, and the defense gets to cross-examine on it. So as long as the defense has a heads up on it, they are allowed to do things they want to do. If it was evidence that was somehow hidden from the defense, you can have motions to exclude it. But if they retest things and bring in new experts, they are allowed to do that. My in-ears are just pulling on my shirt today. So no, I have not seen the letters, but we will obviously need to have a conversation about it. Vicky, thank you for the gifted memberships. SC Girls said, how have they not disqualified any of the Reed tainted evidence? I imagine we will see stuff come up again in motions in limine again, but also I think for the defense, some of it just makes the investigation look bad. So I don't know if they want all of it out. Let's see. Sina, aka Potato Supreme, said, do I remember right that we are now at 4 trials for next year? Reed, Richens, Adelson, and Koberger. Those are what's currently on. Well, and Keefe D, because it's going to get bumped to next year. I don't know how we're going to do it all, but we're going to figure it out because Koberger is going to be months of trial. Months of trial. Richens should be pretty quick. Adelson should be pretty quick. Reed, we will see, but Koberger is going to be a long trial. Parwa, no. Prewa, thank you. I'm sorry that I feel like I always mispronounce your name, and I appreciate you. Sorry if you already answered this, but is the federal investigation still ongoing in the Karen Reed trial? To the best of our knowledge, it is still ongoing. We have not heard that it is over. They are probably not still actively doing the grand jury, but we have not heard any result and we have not heard that it's closed. So I can only assume that it is still ongoing. Stephanie said, recovering from foot surgery, Midas merge. I mean, it has been something that I have enjoyed distracting myself with as well. So let's do a little bit of the, we've got some time. We've got a minute. Let's do some of what's in the Vanity Fair articles. And for those of you that have already read them, I have not read them. We'll pick some of them up. And we'll go through it. Let's see. I'm going to answer this first. Jenny Fart said, have you spoken about the Menendez case appeal? Yes, I covered it on the Monday episode of Quick Bits. So if you are on Quick Bits, I've been talking about the Menendez brothers in Quick Bits. I also put out a reel on Instagram that's also in the app for it. So let's pull up the Vanity Fair articles. Let me grab my news app. Why? Because I use Apple News because it has all the things. Where is it? And why is it not pulling up? Why are you hiding from me? Apple News, let me be great. Where are you hiding? Oh my goodness. Give me one sec. Chat, give me one sec. Emily, do we need a 4th screen pulled up? Yes. Yes, we do. Because I cannot find my news app. There it is. All right. Let's pull up these Vanity Fair articles from Apple News. 2 parts. All right, chat. You know I love you. Where'd it go? Get back up here. Let's see. I cannot put this in dark mode. I don't think that's an option on Apple News. And if it is an option in Apple News, let's see. I don't know where to find it. I feel like it should be an option. I just don't see it as an option under view. So we're just going to roll with it and hope for the best. So let's see. All right. We should be able to pull this up and share screen. Let's switch screen. Let's take a look at the Vanity Fair article. Now we've merged into Hoag's Hangouts and Headlines. Let's Hangouts and Headlines. I'm not really Hangouts and Headlines. We're just going to stories adjacent to our legal coverage, which we do on occasion, especially when we are distracting ourselves. I have not read this. For all of you that have, let's dive in together. For all of you that, oh my God, that type font is small. I regret everything. I regret everything immediately. Why? Why can't I enlarge this? Hold on. There's a way to do it on my from keyboard shortcuts. How do we enlarge keyboard? I've totally forgotten. Because I'm trying to use my mouse to do it. Let's see. Yay! Keyboard shortcuts for the win. Oh, that Emily, you've gone too far. Don't fly too close to the sun, girl. Let's not get crazy. Now the chat can't read it. Oh, my chat just crashed. There we go. We'll see how we go. This is still hard to read. Maybe. Nope, that doesn't make it better. All right, we're going to do our best. This feels incredibly small in the font. I hate it the most. I'll stop complaining in a moment. Maybe. Karen Reed tells her story, part 1, a murder trial in Massachusetts. Okay. After John O'Keefe was found near death. He was not near death. Does anyone think he was found near death? He was absolutely already deceased. But okay. Oh boy. Am I going to have thoughts? What are we walking into? All right. Let's hope for the best. After John O'Keefe was found, Emily D. Baker, note, deceased, in the snowy front yard of a fellow Boston cop, his girlfriend was arrested. As Karen Reed's second murder trial looms, she's ready to talk about what she says really happened. Okay, initial thoughts. This is always a bad idea. This is always a bad idea. She has the right to tell her story on the stand. She has the right to tell her story to the media. It's just not a great idea. I don't think she wants to testify in court. We didn't see her testify in her last trial. I don't think she needs to testify in her trial, but I also can understand the frustration of her giving numerous media interviews before the case is resolved. I think there's room to do this later. I do not like it, but I am not the attorney. I am not the defendant. I also understand how uncomfortable it must be to let everyone talk around you and want to have your voice heard. We saw Alec Baldwin not able to get away from this. Even though he didn't want to talk before the Rust trial, he could not help himself. It is not easy when people talk about you. It is not easy when they are wrong. You want to set the record straight. I don't know if it ever helps. I don't know if it ever helps. Let's see what we think. This is by Julie Miller, October 29th, 2024. This is a photo of Reed at her former home in Mansfield. Did she sell her house? That's my question. All right, let's see if we can embiggen this a little bit more. On an August morning, Karen Reed is wheeling my suitcase into her 4-bedroom Mansfield home. So from August to October, it took a while to fact check, to run through her lawyers. Curious. Wheeling my suitcase into her 4-bedroom Mansfield home, her minimalist colonial is embedded with clues as to her current existence. A Ziploc go bag in case of sudden arrest sits hidden in the buffet of her big dining room. In it, Advil, melatonin, toothbrush, toothpaste, hairbrush, drugstore lipstick, strip of paper with her lawyer's number on it, and a bottle of Laura Mercier foundation. I mean, it's an interesting detail. However, all of that would be confiscated. A copy of Dave Rudolph's American Injustice, a 2021 account of a horrifying prosecutorial misconduct, rests atop a stack of finance books, because she had been a finance professor, a burner phone, and SIM cards purchased after Reed learned authorities were tracking her this year. Are we surprised that they were tracking her? Is stashed in a safe box beneath a scenic painting. In her closet, a framed Rebel Without a Cause poster stands behind the poster board exhibits from her last trial. Read part 2 of this story, including new details that have emerged in the Karen Reed murder case as her January 2025 retrial looms. Well, we're going to go to part 2 next. Can we finish with part 1, please? She's been staying with friends and family, but wanted to conduct our interview in the house. She told me she'd have a security person stay overnight. Said security turns out to be a volunteer, a friend of sorts, who declined to be named for the story, but looks like John Cena and has a license to carry. As Reed said, quote, strangest sleepover ever. I mean, I don't think I'd want a journalist staying in my house. Okay. I don't know. Okay. And it is strange for a journalist to say at a subject's home, but Reed's offer was audacious. Oh, the audacity.
Bruh.
3 days during which she would discuss any and every aspect of her life and complicated legal saga with the Commonwealth of Massachusetts. There would be no lawyer present or conversation parameters, even though anything she tells me on the record can be used against her in her forthcoming trial. I mean, yes, and there's nothing we're afraid of, she told me. Any question you have, I have answers for. My editor and I discussed boundaries. I arrived with groceries for myself, and I booked a backup hotel in case I felt uncomfortable. My family was nervous. Me, 6 months pregnant, bunking with an alleged criminal. Journalists rarely get such unfettered access to any subject. It's awkward. But also, I don't know if you want to. Okay. I mean, it's odd. Like, it's odd. And even with no lawyers present, I wonder if the lawyer said we have to approve the final article before it goes live because they're silent. They're silent as to that. Maybe it'll come up. Keep reading. I don't know. That's strange to me. Especially not someone in the middle of such unusual high stakes circumstances, a defendant in a murder case that's become a national obsession. I guess for some, whose freedom hangs in the balance and whose fate hinges on reliving the worst day of her life over and over again. Her story. Okay. Around 12:20 a.m. on January 29th, after a night of drinking, Reed dropped her boyfriend, Boston police officer John O'Keefe, at the home of another officer, Brian Albert. She watched him walk toward the house where a smattering of Albert family and friends, including a federal agent, were drinking. Then she returned to O'Keefe's house where she lived part-time and went to sleep. Reed awoke about 4 hours later where she panicked to see that her boyfriend hadn't made it home. After calling O'Keefe's friends, interesting language, not her friends, but after calling O'Keefe's friends and discovering no one knew where he was, she returned to the house where she'd left him. There are some details left out, but okay. She found O'Keefe covered in snow in the front yard, unconscious with blood pooled around his nose and mouth. Straining to understand how he wound up gravely injured in a middle-class neighborhood at 6 a.m., she wondered whether she had accidentally backed her vehicle into O'Keefe the evening before. She uttered 9 words that would immediately make her a suspect and radically change the direction of her life. Did I hit him? Could I have hit him? And often in these articles, they do not generally pay for the article, but sometimes they will pay for licensing of the pictures. I don't know if she was paid for this or not, but sometimes photos will be paid for, which I comment on as we see the photo here. By 5 o'clock that night, Michael Proctor, a Massachusetts State Police trooper, asterisk, for now, had seized Reed's car and phone. 16 hours into his investigation, Proctor texted his friends, "Oh boy, we're not reading all of that. Look, I've learned." YouTube is like, no way. There will be serious charges brought on the girl. She's a whack job. See you next Tuesday. Zero chance she skates. She's fucked. And we heard all about that at trial. In a later group, the amount of C-bombs dropped in the trials we've covered still surprises me. In a later group text, the investigator told his supervisors he was searching Reed's phone and apprised them of his progress. Quote, no nudes so far. When someone surmised that the homeowner would surely, quote, receive some shit as well, Proctor responded, nope, homeowner's a Boston cop too. Those came in trial in a different order, but it is what it is. Proctor had called the text, quote, unprofessional and regrettable, but argued that his remarks have zero impact on, quote, the integrity of the investigation. He did not respond to Vanity Fair's questions. Shock. Shock. Anyone surprised by that? Anyone surprised? Reed wouldn't find out about these texts until much later, along with the public. I mean, now there's been motions to get into all of his, not just his phones and other email addresses, but others. Oh boy. In the immediate term, her charmed existence as an equity analyst and adjunct professor at Bentley University dissolved. Commonwealth prosecutors claimed that after a drunken argument, Reed reversed her Lexus SUV into O'Keefe, ultimately killing him, and then drove off. On February 1st, she was charged with manslaughter, motor vehicle homicide, and leaving the scene of a personal injury death. Didn't they fact check this? On February 1st, she was charged with manslaughter. I don't know if she was charged. I think she was charged with leaving the scene then, but the motor vehicle homicide wasn't charged until June. Y'all, didn't anyone just pull did no one just pull the indictments? She was, okay, am I being too picky? She was not indicted on February 1st of the motor vehicle homicide. That came later. I still don't know what evidence they saw that made them upgrade the charges. I'm still waiting. I still don't understand why they decided to upgrade the charges, because they rearrested her. We will continue. Why is my chat window crashed again? YouTube, I blame you. Briefly for my chat window crashing. All right. It goes on to say on February 1st, she was, whatever, there were 2 indictments. She lost both jobs, her health insurance, her car, and her life savings. That is the common plight of criminal defendants. That is not new to Karen Reed. That is incredibly common. There's room for conversation about why prosecutions should be restrained, and you should be able to, prove a case beyond a reasonable doubt before you bring it because of the impacts it has on individuals. But even if she is acquitted, there's nothing she can do to undo all of those things that happened while she was pending trial. I need to pop my chat back out again while she was pending trial. And sorry about that echo. That was as I was trying to pop my chat back out again. All right. I can see it better now. There we go. Hi, chat. Quote, here's their hero quote. I'm not backing down now, Reed told Vanity Fair. I'm in it now. As scary as a potential conviction is, I will go to jail for something I didn't do before I plea out. I will never give them that win. I mean, it's going to be a long fight. Reed is living off what remains in her 401k. Not long after my visit, she sold her house to subsidize her legal expenses. I'm not surprised by that. She still owes more than $5 million in deferred fees for the highly skilled defense team she's marshaled. I am very surprised that they shared the amount of her defense. That amount doesn't surprise me. The fact that they shared it surprises me. So, $5 million in deferred fees. Are you guys surprised by that? Is that number shocking? Reed's first trial ended on July 1st with shock but no conclusion. See if we can make this bigger one more time. Oh, no, that definitely not. With shock but no conclusion, Norfolk County Superior Court Judge Canone declared a hung jury and a mistrial, a conclusion that 5 jurors have since come forward to contest, according to the defense, saying that the jury had unanimously voted to acquit Reed on the charges of murder and leaving the scene and were only divided on the manslaughter charge. District Attorney Morrissey's office plans to prosecute Reed again on all 3 charges, with the trial date set for January. Until maybe later, today, tomorrow, if it gets continued, which I think it probably will. Let's see. Reed's team has taken the matter, to the Massachusetts Supreme Judicial Court and will argue on November 6th for the charges to be dismissed on the grounds of double jeopardy. And we're going to cover it here live at 8 a.m. At 8 a.m. On her side is the ACLU of Massachusetts, which filed an amicus brief backing this argument and criticizing the court. The DA's office declined to answer Vanity Fair's questions, citing the case's active nature. Anything the DA's office says could look like improper pretrial publicity. I'm not surprised the DA's office is like, nope, immediately nope. Reed's lawyers believe the first trial's outcome is just another twist in a strange saga that involves no fewer than 4 law enforcement bureaus, including the Massachusetts State Police, Canton and Boston Police, ATF, and who else? Isn't that 3? Massachusetts State Police, Canton Police, ATF. Well, also, you know who they forgot, you guys?
The FBI! The FBI! The FBI!
How can you forget the FBI? They allege Reed not only did not kill O'Keefe, but is a victim too of a crooked DA, jury tampering, and corrupt law enforcement. If there are any statements from the lawyers, I imagine the prosecution at some point is going to stomp their feet and say this is pretrial publicity, but Reed can talk if she wants to. All right. Other than feeling wrongfully persecuted and prosecuted, I feel incredibly violated, Reed tells me. Police have visited her home 3 times, seized her phones twice, subpoenaed her family's financial records, her private text messages, her most intimate thoughts have been presented to the world. We did see some of her text messages and her voicemails. I guess I think those are more statements than thoughts, but okay. They said dissected and debated by the public. That's true. Her personal tragedy is many people's true crime entertainment. Okay. Megan says, I second an FBI emoji. We probably should. Okay. I don't know. I think I don't think this audience sees this as entertainment. I think it's incredibly valuable. I think there's room between like slimy true crime and like what the fuck is happening. But I understand that there are many facets of the internet, and this case is discussed in many different facets of the internet in many different ways. I don't know if anyone here sees this as entertainment as much as we're looking at this going, what the fuck happened? So I think the law-honored approach to most of the cases that we approach is, I have questions. I would like them answered. And courts need to be public because we need to understand what the fuck is happening. That doesn't mean it's not at times entertaining, because courts are wild. But what the fuck is happening? This investigation is wild. However, I also understand how it has to feel sitting there watching everyone talking about you. But again, Vanity Fair is also here, diving into it. But I get it. And I get it for the victim's family as well, that watching Karen Reed being like, this is happening to me, and her sharing her experience to them is like, okay, but our experience is this. There's so much tension in this case. So I get it. But this case is one that I think, there are many, but this case is one that I think needs an eye on. This investigation is wild. This investigation does not sit right with me at all. And hasn't, because no questions have been answered still. And that is definitely worth keeping an eye on. Anyway, Even though a second trial scheduled to begin January 27th will offer more of the same humiliations and intrusions, plunge her deeper into 7-digit debt, she's pushing forward. I mean, that's a lot of exposition. Quote, I'm not backing down now. As scary as a potential conviction is, I will go to jail for something I didn't do before I plea out. I will never give them that win. I can understand that feeling. Chat, how about you? I can understand that this feels personal for Karen Read, especially after those Proctor text messages. How do you not? How do you not feel like it's personal after those Proctor text messages? I think anyone would. Those text messages are horrifically personal. So it feels like a fight because they didn't treat her like a human. And that's not the way that the system should work. It should not be dehumanizing. Sometimes it's going to feel that way, but it shouldn't be that way to the way that Proctor was dehumanizing Karen Read. That shouldn't be happening. And if that is the way law enforcement feels, it is time to take a step back and maybe take a desk for a minute. Her pent-up feelings pour out of her with the urgency of a person facing a maximum sentence of life in prison, though she occasionally wisecracks in her tour through the wreckage. Quote, I never knew an unopened shredder could make me so sad, she says, pointing out the factory-sealed machine, which she had hoped to use to destroy her reams of legal documents after an acquittal. Okay. If I can get the entire truth of this case out in the public forum, that, to me, is priceless. I think the public would also like to know just what the fuck happened. In the beginning. Oh, boy. Hey, blast from the past, how's things? That was the Facebook message Read received from O'Keefe in the spring of 2020. The pandemic was first taking hold, schools were shutting down, and Read hadn't seen O'Keefe in 16 years. That's an out-of-the-blue Facebook message. They'd first met at a birthday party for O'Keefe's sister, Kristen, in Boston in 2004. Read didn't know Kristen, but she was tagging along with a friend from Braintree, where the O'Keefes grew up. She thought O'Keefe was cute. They exchanged numbers and dated for a few months, a fleeting 20-something romance. In the intervening decade and a half, Read and O'Keefe both experienced harrowing personal traumas. Read endured 10 surgeries in 18 months to treat and ultimately diagnose Crohn's disease. Less than a year after her last major surgery, she was diagnosed with MS. O'Keefe, meanwhile, lost Kristen to brain cancer in 2013, then lost his brother-in-law, Kristen's husband, from a heart attack. O'Keefe, known as JJ to his niece Kylie and nephew Patrick, became their guardian. Read thought the surviving of these life-altering events helped to forge a deep bond with O'Keefe. She felt for him and the kids. Quote, I felt like this is a perfect situation. It's a Karen-sized hole in this house, and I have the energy and resources to fill up. The relationship progressed quickly in the confines of the pandemic. Read, who could work remotely, rearranged her schedule to be at O'Keefe's house most days, supervising the children's Zoom schedules and making them lunch, while O'Keefe worked a desk job in the Sex Offender Registry Information Unit at the A1 station in Boston. And a picture of Read and O'Keefe at a bar with hockey on in the background. It says, as in any relationship, issues bubble up. O'Keefe resented that Read got to do the fun parts of parenting while he played the disciplinarian. I mean, I get it, but also she's not their guardian. So, I mean, her being the disciplinarian is not really on her. But then again, this is her recitation of what she thinks his issues are with her. So there's that. When the kids returned from a trip with their grandparents, Read recalls that Kylie and Patrick walked past O'Keefe to hug her first. O'Keefe felt the kids preferred Read because she spoiled them with go-karts, fancy haircuts, and shopping trips. She thought they could feel her warmth and O'Keefe's stress. Okay. He never adequately mourned his sister, according to Read. I mean, that's his business. Also, his sister died, his brother-in-law died, and then all of a sudden he had 2 kids. So, yeah, he might not have processed that well, but we get it. He never adequately mourned his sister, according to Read, and struggled to manage his own grief and the children's increasingly complicated needs, emotions, and otherwise. O'Keefe saw a therapist. This is a lot of O'Keefe saw a therapist with them at one point, but when the shrink introduced board games, O'Keefe checked out. I think that's part of his stock. Reed contemplates now. Can we let him be? I think that's just part of his stock. Reed contemplates now. This Irish Catholic south of Boston, rub some dirt on it, drink through your problems mindset. Drinking increased for both of them on the weekends, which she now regrets, but rationalized at the time as them unwinding after a hard week. I mean, also 2020, I mean, it feels like a fucking vortex. It also feels like it's looming, but it feels like a vortex where there was a lot going on. Drinking increased for both of them on weekends, which she now regrets, but rationalized at the time as them unwinding after a hard week. Once O'Keefe had a drink or two, quote, that was when he was the most relaxed, Reed said. He would be easygoing, but then it was this vicious cycle that he's hungover the next day. Are you telling me this man who drinks regularly is hungover after 2 drinks? During a New Year's group vacation to Aruba, Reed says O'Keefe and his friends cracked beers at 10 a.m. Is anyone shocked by any of this? And drank till sundown or man down, whichever came first. Whose joke was that? Was that the writer? Or was that Reed? What do you guys think? Let's see. His friend cracked beers at 10 a.m., drank till sundown or man down, whichever came first. She says she caught O'Keefe kissing another woman. The woman denied it at trial. Oh, the Aruba of it all. That same January, Reed engaged in her own flirtation. She exchanged texts with one of O'Keefe's contacts, Brian Higgins, an ATF agent. It was a brief thing and petered out as quickly as it started. I knew Higgins found me attractive, she said. It helped me emotionally validate myself, which is embarrassing to admit. Didn't they kiss too? No? Nowhere to be found. It's left out, the kiss with Brian Higgins, by the way. But we watched the trial, so, you know. On Friday night, January 28th, Reed and O'Keefe had been drinking with O'Keefe's buddies at the waterfall. His buddies, by the way, were some of my favorite witnesses in this trial. The buddies he went to the waterfall with, no, the buddies he went to was the waterfall first. No, C.F. McCarthy's with, and then the Colakeithises from the waterfall. 10 out of 10. But the rest of it became messy. Let's see. Reed and O'Keefe had been drinking with O'Keefe's buddies at the waterfall, and then they went to descriptions of waterfall inserted here. It was around midnight, and the snow had just begun falling when Brian Albert invited everyone in a group to his house afterward for drinks. So they left out the C.F. McCarthy's of it all. Okay, whatever. We know what was supposedly happening over there. Let's see. That night, Reed and O'Keefe were joined by a cluster of the veteran cop's family members. His wife, Nicole, his brother, Chris, Chris's wife, Julie, Nicole's sister, Jennifer, McCabe's husband, Matt, plus Higgins and an unrelated couple, Karina and Nicholas Colakeithis. Leave the Colakeithises out of all of this. Just protect them at all cost. I thought they were great witnesses. They seemed like fun. They also seemed like the one time they're like, it's going to be a blizzard. We'll go out with the parents from the basketball team. And then they end up having to testify at a murder trial. And they're like, oh, fucking hell. This is the last time we're ever going out with anybody. Never again. They just try to go out with some of the other parents, which can be awkward anyway. Anyone who has tried to make adult parent friends with like the kids' friends knows that this can be an awkward interaction. And then they end up testifying at a murder trial. I have so much empathy for the Colakeithises. Karina was like, I just had a long day at work. Then there was basketball. I just wanted to go the fuck to sleep. And my kids were like, Mom, you never go anywhere. And she's like, fine, I'll go out. You guys are harassing me. Tell me I never go anywhere. Mom, you're not any fun. Fine, I'll go. Gets herself out of her house, goes to the bar, and ends up having to testify at a murder trial. Leave their name out of it. I feel for them so much. They were just like, why are we even here? The table was a high top. Like what? The one time. And if the kids ever say again, but Mom, you're never fun. It's like, remember the last time Years later, we're still dealing with it. It's got to be very surreal for them. Oh, peer pressure, even when you're an adult, still happens. It says that when Reed woke up the next morning, she panicked that O'Keefe was not home. They left out a whole bunch of calling and voicemails. Like there's a whole bit that skipped over this, but okay. Reed woke up the next morning panicking that O'Keefe was not home. She met up with his two friends. I can understand in hindsight why she's like, these people aren't my friends. Like I get it. I get it. Because this is now being told in hindsight. Met up with his two friends, Jennifer McCabe, who was at the Albert home when Reed dropped off O'Keefe, and Carrie Roberts. I think Carrie Roberts truly was John O'Keefe's friend. Of all of the witnesses from that night, Carrie Roberts' testimony rang the most true for me. It says at about 6 a.m., the women pulled up at Alberts' house at 34 Fairview. Reed spotted O'Keefe in the front yard. Hysterical, she jumped out, cleared snow from his bruised and bloodied face. That's descriptive. Began mouth to mouth. Roberts administered chest compressions. McCabe called 911. At times, Reed laid on top of O'Keefe, desperately trying to heat up his body, which had cooled to 80 degrees. Emergency vehicles raced up Fairview. We watched all of the video. I'm skipping through this. EMTs delivered her around 8 a.m. At the same time, O'Keefe was pronounced dead. Quote, the patient was hysterical. She is actively grieving. She states she does not belong in care. She just wants to know what happened to her boyfriend, observed attending physician Jonathan Rice. The EMTs who transported her really thought that she was just grieving and in shock. They were like, she doesn't need a hold. Like, what are we doing? She's responding to a chaotic situation. She doesn't need a hold. But her dad had called, and that happened. So the notes from the doctor say that she did not need a hold and had no psychiatric history. She was having a response to a situation. When Reed's father, Bill, arrived at the hospital, a nurse briefed him, your daughter wants to know whether or not John O'Keefe is dead. We can tell her, you can tell her, or you can tell her with us present. I'll tell her, Bill said. He was led into Reed's room where he told his daughter simply, he's gone. Reed insisted that her father take her to O'Keefe's house to see Kaylee and Patrick. The rest of the O'Keefe family was already there, including his mother, Margaret, who goes by Peg, his father, and his brother. They had also come from the hospital where they identified the officer, John's body, and saw his descriptive. They identified his body. He looked like he went 5 rounds with Mike Tyson, was Paul's response, according to the Reeds. I don't know when that is from. I don't remember. They say Peg made her own assessment. I think he looks like he got hit by a car. Reed was thunderstruck by the unexpected hostility. Her family realized it was time to leave. Reed and her father went upstairs to quickly pack her medication and belongings. And then she hugged and kissed Patrick and Kaylee for what would be the last time. A few days later, Reed was court ordered to refrain from contacting the O'Keefe family. Did we know that? That didn't come out at trial. I don't know if that was known before this, but that surprises me. If she hadn't been charged already, after charging, not contacting victims or witnesses is not surprising. It felt like all of a sudden this went from being my house to I'm persona non grata, she told me. As they left, she told her father, Dad, I don't know what happened, but I feel like Peg thinks I did something. When they got home, Bill Reed searched. That's a change of story. Bill searched criminal defense attorneys in Boston. David Yannetti's name and picture popped up. It seemed that also Karen had searched that, but okay. David Yannetti's name popped up. I mean, Google's working for Yannetti. Yannetti, well done with the search terms. Yannetti had spent his first decade of his career as a prosecutor. As the Middlesex assistant DA, he put 2 men behind bars for one of the county's most heinous crimes, the 1990s. What is happening? Okay, the assault and murder of a 10-year-old, Jeffrey Curley, whose attackers lured him with the promise of a new bicycle. Bill's vetting was more on instinct, a devout Catholic who prays every day and paid his way through college by working as a night guard in Fall River. Bill decided on Yannetti because he looked like an honest man. I mean, having two former prosecutors looking at this case like Yannetti and Jackson can help me understand how annoyed they are with this entire case and kind of outraged they are, because same. Hey, T, what's up, buddy?
I'm leaving for auditions, so I thought I'd give you a hug.
All right, thank you. Love you. Have a good
Shoot, I
audition.
didn't realize I was wearing my show shirt.
It's okay.
Y'all can't see you.
Wear your show shirt. Good luck teaching.
School on it.
Good luck teaching your choreo.
Mm-hmm.
All right.
I have an interview in like 20 minutes.
Okay.
So I gotta get going.
Drive safe. Love you, buddy.
Maybe.
You will do great. Have fun with your choreo. Travis has auditions for Winter Guard. All right. Let us continue on. So, thank you guys. I know for those of you that are OGs, you're like, he's taller than me. He's taller than me. He's taller than me. So, T knows we had some issues with people trying to find where he went to school during some cases I've covered. So T kind of knows that we try to make sure that that's not super easy to find. And for those of you that have seen me at school events with T, that have seen me around band events, everybody has been so incredibly kind and understanding that. It's been amazing. Like, this community is just so absolutely incredible. I know you guys have seen him grow up quickly. So he's very mindful of it, which I appreciate. And our community's been really mindful of it, which I appreciate. And the band community has been really mindful of it. And they're not just protective of my kiddo. We have kiddos at our high school that are kiddos of musicians and kiddos of politicians and stuff, and not a private school, public school, just where we live. But everybody in the community in Nashville and around Nashville is incredibly mindful that people want their kids to be able to have a normal experience no matter what their parents do. And there's a lot of parents here that work in all different kinds of industries. And it's just more chill than Los Angeles was about that stuff. It's just Nashville's a whole different vibe. Nashville's like, all right, well, I mean, this is the barbecue restaurant Reese Witherspoon likes to go to, and nobody makes it an issue. And it's just actually really, really compassionate, I think is the best word. So I'm excited for T's tryout. Let's see. All right. Shall we continue after we've gotten past Yannetti's background as a prosecutor? Again, doesn't surprise me looking at this case as a prosecutor. Yannetti and Jackson are going, how the fuck is this going to trial? Like, what? So, Tian said, it feels like not that long ago, he barely had to stoop to hug you. I know, taller than me. So just said, Emily, did you say Reese Witherspoon? Yes, is local, as are a ton of folks, but it's not a secret that Reese Witherspoon is local because she talks about living here all the time. All right. Shall we continue? Shall we? Yes. Let's see. So Karen Reed's dad thought Yannetti had an honest face. They go on to say Massachusetts State Police were moving quickly. They seized Reed's car and phone less than 12 hours after O'Keefe was declared dead. She knew she was a suspect, but her devastation trumped fear. She was still confused as to why O'Keefe's body was on the Alberts lawn and was shocked he was dead. Quote, I'd been with him all week, she told me. We had been intimate okay. We'd been intimate the night before and now he's gone. I'm sure she was absolutely shocked. Again, lots of alcohol involved. Yannetti told Reed to prepare for an arrest. So racked by grief and disbelief, she zombie walked through her morning ritual. She showered, did her makeup, blew out her hair, picked out a sweater that would be comfortable in jail, and waited for hours on the overstuffed white couch in her living room where I sat while she recounted this story. Dun, dun, dun. 3 days after O'Keefe's death, she was taken into police custody. An attractive, highly educated finance professor accused of killing her cop boyfriend and leaving his body on another cop's lawn was catnip to Boston media. That's so dramatic. The morning after her arrest, I get that I also get accused of being so dramatic. Like, I get it. The morning after her arrest, cameras rolled as she was escorted in handcuffs to her arraignment. She pled not guilty on all charges, was released on $50,000 bail. A cousin with a criminal record called her with advice. I've pled to charges where I wasn't even in the state where the crime happened. I wanted to get out of jail if I couldn't post bail, and I didn't have David Yannetti. The cousin warned her that prosecutors don't always care if they have the right guy as long as they have someone behind bars. That's a closed file for them, he said, and then added, question everything. Okay. Ted, no, I'm definitely not Reese Witherspoon's lawyer. I'm just saying. There are very, very famous people around and everybody's chill about it. That's all. All right. It said Yannetti received a different kind of call on February 2nd. Within hours of Reed's arraignment, a man with a gravelly voice claiming to have a background in Boston law enforcement made an explosive claim. Really? He told Yannetti... Is this Reed disclosing what Yannetti told her, or did Yannetti give quote to the article? Because if Reed is starting to disclose conversations she had with her lawyers, it's a terrible fucking idea. But it's already here. So continuing on, Yannetti received a different kind of call on February 2nd. Within hours of Reed's arraignment, a man with a gravelly voice claiming to have a background in Boston law enforcement made an explosive claim. He told Yannetti that Brian Albert and his nephew had beaten up O'Keefe on January 29th. I mean, we knew that. We just didn't know where it came from in this way, I think. When O'Keefe didn't come to, said this mysterious man, Albert and the unnamed, quote, federal agent put O'Keefe's body on the front lawn. When Yannetti called him back for a more thorough interview, he backtracked, saying he was only speculating based on photos of O'Keefe in the news, and ultimately recanted the tip altogether. But Yannetti points out that photos of O'Keefe hadn't been released at the time of the first call, and other details from the tip lined up. Higgins, an ATF agent, had been drinking at the Albert home that morning, as had the Albert's nephew Colin. Until the tipster's call, Reed and Yannetti hadn't known that Colin was at the house, as he later testified he was, because his name was not in police reports. Do they even have all the police reports at this time? In February, a funeral was held for O'Keefe in Braintree. Dozens of Boston police officers saluted O'Keefe's casket. Okay. Reed was not there, in part because of the stay-away order, but views the pomp as performative. Quote, this whole Irish cop departed bagpipe thing, says Reed. Oh boy. There's nothing holy about this, she says. I think it is the biggest farce, maybe only second to my trial, that the people who were there in the cold outside the church were nowhere to be found in terms of actually delivering justice for John O'Keefe. Okay. There weren't many cars in the driveway, and Reed felt uneasy. McCabe had conveyed the invitation, so Reed wasn't sure how welcome the couple actually were. O'Keefe said he'd check out the scene and report back, but minutes passed without word. I got pissed, Reed tells me now. Is this going back to that night then? Okay. A breakup where kids are involved is a high-stakes decision. In January 2022, despite their troubles, neither O'Keefe nor Reed were willing to give up on the family dynamic they had forged with Kaylee and Patrick. That fateful night, they still loved each other. I mean, okay. They cuddled at the waterfall. I mean, that was true. And witnesses described them as affectionate. That's also true. Albert invited the group back to his house to celebrate his son's birthday. I mean, I think it was Jen that did, actually, but okay. Beyond a bar run-in the week before O'Keefe died, he never really socialized with Albert, even though they were BPD living in Canton and had McCabe in common. Albert had an alluring reputation. He helped unmask the Boston Strangler in 2013 and capture the Craigslist killer before that. The night he died, O'Keefe was eager to join up for a nightcap, as retold by Reed. When he and Reed arrived at 34 Fairview, though, she wondered whether they were at the right address. There weren't many cars in the driveway, and Reed felt uneasy. McCabe had conveyed the invitation, so Reed wasn't sure how welcome the couple actually were. O'Keefe said he'd check out the scene and report back. I wonder if some of this, I don't know. I just wonder if we're not talking about all of the Brian Higgins of it all. I just wonder if we're talking around the Brian Higgins situation of Reed feeling uneasy. I'm just curious. I got pissed, Reed tells me now. She knew that a woman O'Keefe used to hook up with lived a few houses down the street. The Bella child's mother? The Bella child's mother? He's got to be screwing around, she thought. I didn't think he was physically incapacitated. After about 10 minutes of waiting, Reed drove to O'Keefe's house to be with Kaylee, who was home alone. If you think he's hooking up with somebody, you don't just go into the house. Okay. To Reed, it felt like Aruba all over again. So recent. She sent O'Keefe a barrage of angry voicemails and texts. Oh, there they are. John, I'm going home. You are fucking using me right now. You're fucking another girl. Kaylee is sleeping next to me. John, I fucking hate you. This is fucking dirty. I mean, they edited those a bit. For months after Reed was first charged, Massachusetts State Police were back at Reed's house to arrest her again, this time for second-degree murder. Oh, there it is. She and Yannetti were stunned. She didn't know a rearrest was possible, and her lawyer hadn't given her a heads up. Defendants can be upcharged when significant new evidence is discovered, but Reed and Yannetti considered the additional evidence cited to be a stretch. In an interview, Patrick had claimed O'Keefe and Reed argued a decent amount of time, and Kaylee recalled O'Keefe telling Reed their relationship was over, with Reed refusing to leave the house. The Commonwealth also cited Reed's estimated BAC based on a sample taken at the hospital. Is that really what they're hinging the upcharge on? Because, well, you know how I feel about it. It is a stretch. It is just a freaking stretch. Also, if you think she's intoxicated, is she intoxicated to the point where she's driving recklessly, or is she intoxicated to the point where she's committing murder? Like, which? Okay. The second arrest was Yannetti and Reed's first clue that something was, as they say, amiss. Quote, it was so dirty and underhanded that they would go behind my back, Yannetti tells me by phone. Oh, so Yannetti did give comment. Okay. Cue the Commonwealth getting mad. The DA requested Reed's bail be set at $500,000. I believe it was to scare me and get some kind of a plea deal going, Reed says of the second arrest. I mean, I don't know if I quibble with that reading of the situation. Do 2 years on a lesser manslaughter charge and you'll be free, which we were never going to consider. Interesting that they were offering her 2 years, but also I can understand why her lawyer is like, yeah, we're not doing that. At Reed's second arraignment, Yannetti argued that his client had no reason to flee. Her Crohn's and multiple sclerosis treatments were in Boston. Cannoni set Reed's bail at a comparatively low $100,000. Insert artistically blurred image of Karen Reed into the article. The day after I'm upcharged, David's like, don't tell us what your lawyer said. Don't tell us what your lawyer said. David's like, quote, listen, like, I want the tea, but also like, no, don't. The day after I'm upcharged, David's like, listen, I know this is the worst time to have this conversation, but my fees double for murder. It's the most lawyer shit ever. Hey, just so you know, a murder case is different. By the way, this is a real awkward time, but it's expensive to be me. So we're going to need to rethink that retainer. The fees weren't as frightening as the legal shock, though. At that point, says Reed, David and I realized this is fucking dirty. This is not, you said something that was taken the wrong way at the scene and they got the wrong guy. This is intentional. They're framing me. In September 2022, Reed and Yannetti were running into repeated roadblocks trying to get basic evidence from the Commonwealth. They hoped to get Google geofence data, which would identify every cell phone on the Alberts property on January 29th. Desperate for guidance, Reed emailed Alan Jackson, an LA-based lawyer who used cell phone data to get the 2019 groping case against Kevin Spacey dropped. Jackson had worked on the other side too as an LA County prosecutor. He also ran for DA at one point. He put Phil Spector behind bars for the 2003 murder of Lana Clarkson. Since then, he's built a reputation of one of California's top and most expensive trial lawyers, representing a Venice Beach hotel owner charged with murder, an NBA basketball player facing domestic assault charges, and a 22-year-old Bakersfield man who stabbed his brother in self-defense. They've left some people out there. Do you think it's intentional? Do you think they've curated his CV to leave out some of his defendants? Chat, do you think? I don't think that was unknown. Do you think that was intentional? Chat, you let me know. Was it intentional? Also, the and most expensive was this article, not me. So let's see. The chat's like, oh yes, they would leave him out too. The chat's like, yep, you don't put Weinstein's name into anything. They're like, yep. Leave it out. They're like, do not mention Weinstein at all. It says Jackson gets more than 100 representation requests monthly, but the subject line of Reed's email stood out: murder of a Boston cop. He clicked on it and read her plea. I am frightened for my life against a blue wall and therefore marshaling whatever resources, advice I can find. On a call with Reed, Jackson agreed to share his cell phone data related motions and asked to hear more about her case. After learning that she was being accused of fatally hitting O'Keefe with her SUV, the lawyer asked to see photo of O'Keefe's injuries. Yeah, he was just like, yes, let's do that. Reed immediately sent over a few revealing O'Keefe's bruised and swollen eyes and the cuts above his right eye and nose, but it was O'Keefe's right arm, which looked like it had been clawed, that caused Jackson to exclaim, "That's an animal attack." Jackson later said by phone, if there's any medical examiner or DA or lead investigator out there claiming this is from a car, that's bullshit. And if that's not true, what else isn't true? That's 100%. That's all. I wonder if he toned that down a little bit from that's fucking bullshit. But I can understand when he's looking at the photos, the ones that have been made public, and everything we learned from the autopsy report, that he's looking at the autopsy going, no. Because most DAs have seen a lot of car accidents and pedestrian versus motor vehicle. So I wouldn't be surprised that Jackson would look at this and be like, something is not matching up here. The thing about LA versus I think almost every other jurisdiction in the country is it is high volume cases. So I would imagine if you looked at the volume of cases DAs in LA handle versus other jurisdictions, it is incredibly, incredibly high volume. So to Jackson's benefit, he handled quite a lot of cases. I mean, also to my benefit, but we're still on Article 1, folks. Emily, was it supposed to be a short stream? I mean, they're saying the police theory of what happened that night is evident in the charges, but what Reed and her defense team believe happened involves a fatal fusion of alcohol, testosterone, and bad luck. They allege O'Keefe encountered some combination of Brian Albert, Brian Higgins, and Colin Albert in the basement, and the fight turned dangerously violent. That we know is their assessment. Reed's defense offers several other possible catalysts for a disagreement, such as Higgins' flirtation with Reed. Higgins, who testified he did not encounter O'Keefe at the bar, did not respond to Vanity Fair's questioning. Are you surprised by that, Higgins? Where's your phone, Higgins? Another is O'Keefe's alleged antagonistic relationship with Colin Albert, who lives two doors down. Colin testified there was no animosity with O'Keefe, and he left the Albert home around midnight before O'Keefe was dropped off. He did not respond to Vanity Fair's questions. I'm not surprised. I appreciate that Vanity Fair has put in the, this is what they said at trial. I appreciate that. Let's see. In any of these case scenarios, the defense believes the Albert's German Shepherd Chloe was a factor. I'm not going to rehash this. We know this from trial. Let's see. We've heard about Chloe's prior instances. We've got a picture from the courtroom of John O'Keefe's arm. We've heard about the home. Let's see. This is testimony from trial. We're going to zoom through it. We watched the trial. Reed spent her first few months after O'Keefe's death mourning him, reminiscing, and trying to distract herself from her predicament. She wallpapered the house, cooked with her mother, and read. And then they talked about what she read, including The Count of Monte Cristo. Reed was still confounded. Karen, like, just start with the SJM series. It will keep you busy for quite a while. Just all. There's lots of reading to be had. Reed was still so confounded by O'Keefe's death that she was open to the idea that she could have accidentally hit him. Quote, I told my parents, if I did anything in any way, I'll pay my dues, she said. That's how this should work. I want to know the truth, good, bad, and ugly. She hired a private investigator, even sought out materials that could prove she was guilty, like security footage from the Albert home. But Albert said he had never installed a camera that his wife gave him. I have questions. Nor was there security footage from homes on the street, like the homeowners across from the Alberts who work for Canton PD told Reed's private investigator that his camera did not pick up anything from 34 Fairview. Such an odd coincidence of all these cop houses with no cameras. Weird. It's just weird. Security footage from the library that Reed drove by between 12:37 and 12:39 should have shown whether her taillight was smashed, but that precise 2-minute time frame of the video was missing when the Commonwealth turned it over to Reed's team. The Commonwealth says they turned over the entirety of the video that Canton PD gave them. Reed told me about a rumor that there were texts between her and her lawyer in which she implicates herself, texts the police supposedly read when they confiscated her phone, but will never be released because they're privileged. I mean, okay. If she's texting her lawyer, like, what if this, what if that, it doesn't matter. Because again, conversations between your lawyer on a confiscated phone should not be reviewed. Proctor, the state trooper himself, referenced an exchange on the stand saying that he stopped looking through the phone when he saw messages between Reed and, quote, an attorney. Yeah, the attorney that he fucking hates? That guy? All right, we're switching out water. Water part 2. Let's see. But Reed and Yannetti each point out that they didn't communicate until after MSP had seized her phone and car. That's interesting. I didn't even have a cell number for David until several hours after Proctor left with my phone. Reed says I never texted him on January 29th. Proctor testifying on the witness stand that he saw text between David and I is a provable lie. I am curious about that. Very curious about that. But I wonder, because that is some new information, I wonder if her phone was not properly turned off, which, can we imagine a scenario? Can we imagine a scenario in which Karen Reed's phone was not properly stored? I can. If her phone was not properly turned off and she got a new phone that was connected to the same iCloud account, then the iCloud could still be updating. I don't remember what they said about putting her phone in airplane mode. I don't remember about them downloading it, but I could see a scenario where both things could be true with her texting after they took her phone and her phone still updating from iCloud, but I would need more information. Both could be true, but both could be true. However, would I be shocked that Proctor wasn't being accurate about something? No, I wouldn't. But they also seized her phone again later. So again, both things could be true because they seized her phone again after this. So I would need to go back and look at the timing because her phone was seized again. That said, the Proctor problem with this case is not small. Reed has poured over tens of thousands of pages of legal filings and police reports. She has played the waterfall security footage on repeat. She has scanned every text, screenshot, and Google search on O'Keefe's phone for buried clues. Initially, it was difficult to look at O'Keefe's autopsy photos and, quote, torture to imagine, quote, what did he feel? Did he know he was freezing? Was he waiting for me to come back? She has scoured social media, going down rabbit holes of Facebook posts featuring Proctor with various Albert family members, even a post where Proctor's mom called Chris and Colin Albert her second family. A courtesy to the family. When the trial began in April, meanwhile, Adam Lally, a prosecutor who worked for Norfolk since 2010, assured the court that Proctor had no conflicts. Well. These are not people that know each other, Lally said. Sir. These are not people that know each other, Lally said. The prosecution produced 68 witnesses, at least 9 of whom were related to Albert by blood or marriage. Reed had 6, including a snowplow driver employed by Canton. Lally did not respond to Vanity Fair's questions. Shocking. Leading up to the trial, Reed's team struggled to get basic discovery. That should never happen. Even that was a fight, said Elizabeth Little, another California lawyer on Reed's team. We did numerous discovery requests, filed a motion to compel. We were given JPEG copies of photographs and zero metadata that were blurry and useless. After 7 months of litigation, it comes out they don't have the original photos. They came from a phone. The phone doesn't exist anymore. Initially, you think it's just incompetence. The more we dug, the more we realized the stuff we were looking for was never gathered in the first place or was being intentionally withheld. It became hard to believe it was all accident or mistake. Okay. I mean, I see where Little's coming from. That shouldn't happen at all. Proctor seemed problematically conflicted from the outset. I don't disagree. The investigator appeared in social media photos with various Alberts and McCabe's back to 2012. We know all of this. We know about the 67 phone calls. I think it's a problem too. I don't know many that think it's not a problem. Does anyone think it's not a problem? Just how hard is it to have somebody else investigate this case? The answer is it's not hard if you're not looking at the outcome. Forget about the allegations of the victim being killed inside the house, says Doug Luzian, a Boston defense attorney who has represented law enforcement for 4 decades, but is not working on the Reed case. He, like many legal analysts, believe Reed should have never been tried for second-degree murder. I mean, it's a fucking stretch. As soon as these people who Proctor was acquainted with were identified as witnesses, he should have dropped out of the case. It was a system failure by the state police. Agree. Instead, Proctor declared Reed guilty via text the day he started the investigation, which might be why he didn't drop out. Based on all those text messages, it might be... The Proctor problem is a big one. About 6 months later, while the probe was underway, Proctor and Albert's brother Kevin, the Canton cop, went out drinking. The next day, Proctor texted Kevin that he left his badge in Proctor's cruiser. Kevin responded, "Did I take my gun?" The morning of January 29th, when McCabe's 911 call about O'Keefe being found on the lawn came in, it was Kevin's Canton Police Department coworkers who responded. Yep. One called 2 off-duty officers to report to the scene, including Sergeant Michael Lank, who had known the Albert brothers since childhood. In 2002, while Lank was off duty and drinking, he ran into Chris Albert, who told him that he was being harassed by a pair of brothers. Lank got into a fist fight and summoned police backup, punched one alleged assailant in the face, and was accused of spitting in the face of another. We heard about all of this, some of it on the record, some of it in front of the jury, some of it not. But again, conflict. The officers said they had no reason to believe O'Keefe had ever been inside the house. McCabe did not respond to Vanity Fair's questions. I'm shocked. The Commonwealth's key evidence against Reed had been her red taillight. We know this. I'm going to scoot through their summary of the evidence. We saw that. 1 week later, after multiple searches by law enforcement, former Canton Police Chief Ken Berkowitz reported spotting more taillight pieces on the yard from his moving vehicle during a random drive-by. Reed said she had always considered the taillight to be the cornerstone of the whole case. It's the only concrete evidence that connects me to the crime scene. No evidence was found until they had the evidence. I mean, the cell phone too, but she doesn't dispute being in the area. Everyone knows she's in the area. The taillight was not the only discrepancy that came up at trial. The snowplow driver, a witness for Reed, was adamant that he saw no body when he drove by at 2:45 a.m. His truck had a high vantage point with bright lights. he noted, and he constantly scanned the periphery for obstacles. When he passed the house a second time at 3:15 a.m., he saw a Ford Edge, the same model car Albert drives, parked in front. This was unusual, he said, because the Albert family normally does not park on the street, and it's standard protocol for him to call in a vehicle on the side of the road. During cross-examination, the prosecution presented a different timeline, calling into question the driver's account. Well, the timing. As a courtesy to the Alberts, whom he had known for decades, he did not call it in. That's the end of part one. So a few new things were learned there. Some are helpful, some are not, but is it anything new, really, that changes? Does any of that change your mind, or is all of that kind of along the lines of what you thought about this case from watching the trial? Let's see what part two says. Where is it? And then eventually we have to wrap up because it's almost 3:00. Karen Reed tells her story, part two. A new trial looms in Massachusetts as new details emerge about the Alberts German Shepherd that I'm curious about. I should have swooped because we're going to part two. As new details emerge about the Alberts German Shepherd, the ACLU joins Reed's request to drop the murder charge, and Judge Beverly Cannoni prepares for a January retrial. That's probably going to be in April. Okay. Read part one of the story. Yep, thanks. In Massachusetts, defendants need court approval to subpoena documents or physical evidence. Oh, that's not unusual. Norfolk County Superior Court Judge Beverly Cannoni agreed to a hearing in May 2023 before trial to determine whether Karen Reed could subpoena phone records from Albert and McCabe, but they opposed the motion. Cannoni canceled the court date and denied Reed's request. 2 months later, Reed's team asked Cannoni to recuse herself, claiming the appearance of bias. Aidan Kearney, the blogger known as Turtle Boy, who had been covering the Reed case, said he received Facebook direct messages from the McCabe family member suggesting family ties to the judge. Cannoni rejected the motion too, saying, "I've never socialized with McCabe or any family members or witnesses who have been here in court." Again, it is difficult in small areas, but appearance of impropriety is still appearance of impropriety, and that can be a problem. Let's see. She added, "I reject the notion that untrue and unsubstantiated rumors spread on the internet can force a judge to recuse herself from a case." I'm not surprised that the judge wasn't just like, "Yep, this is a shit show. Y'all, bye." The judge could have said, because there could be, I don't know if this is true or not, but because I know some of these individuals, if that's true, if she doesn't know any of them, then there's no basis for it. But if she does know any of them in any way, there is room to say yes and bye. Sorry, I got distracted by kids that are not my own in my yard. So there's room for yes and bye. Let's see. More reports about the judge that I'm not going to get into because, again, the judge didn't recuse herself. That's not been appealed on. And if it is appealed on, we will cover it. It goes on to say a year after O'Keefe's death, Reed got a partial extraction of McCabe's phone, contrary to MSP reports, which found no relevant search history. Reed's expert Green discovered that McCabe Google search "house long to die in the cold" at 2:27 on January 29th and later deleted the search. Of course, that's not what the state says. And we know. There are a lot of butt dials. There are a lot of phones mysteriously disappearing. The phone activity in this case is odd. So they go through Jen McCabe denying the search, denying deleting the search. The prosecution expert said the timestamp is not indicative of the time of search, claiming that that's when the window was open. We heard all the testimony about that ad nauseum. They say Jackson's cross-examination of McCabe became so heated with the prosecution witness repeatedly asking to see her prior grand jury statements that as one juror, one of the jurors spoke to Vanity Fair. As one juror told Vanity Fair, it felt like they should have been served drinks and appetizers. That's odd. That's odd. Supposedly, this is the most traumatic thing in your life and you don't remember what you said. That juror adds, there were so many times I wanted to just yell out, can you shut up? Tell the truth. Just tell the truth. What? Did anyone else feel that way during some of that testimony? Can you shut up? Oh my God. I mean, wait, you guys are saying go back. Vanity Fair hired a phone expert to look into Jen's phone. Okay, we'll back up. For those of you that read it before, we will back up. Let's see. Vanity Fair asked Umit. Oh, Umit, I'm going to kill that last name. I apologize. A PhD at Purdue's Department of Computer and Information Technology who specializes in iPhone artifacts and the limitations of digital forensics to evaluate the prosecution's expert testimony, as well as an affidavit from Reed's expert. Why not the testimony from Reed's expert? Quote, based on my research and expertise, I concur with what I see in the affidavit from Richard Green, the expert emailed Vanity Fair referring to Reed's expert. Though the browser tab was opened earlier than the searches, the timestamp for the search items is recorded for searches and stored in the database, not at the time the tab opening. He noted that Green additionally verified the search times with associated wall files that are occasionally overlooked. So Vanity Fair's expert didn't review the testimony, did review the affidavit, and agrees with the defense. But does it answer I don't, again, I think, and I will take criticism for this, I think a lot of what's going on with the McCabe's is a distraction. I don't think the state ever answered the fundamental question of what happened to John O'Keefe. I understand the interest in all of this, but I don't think we ever got to the state in their case in chief answering what happened to John O'Keefe. And then the fuckery sideshow comes into all the rest of it. But I don't think the state ever answered the first question. And I wonder if with the juror sitting here going, just shut up and tell the truth, I wonder if the juror felt it too. Like, yeah, we're going to fight over Jen McCabe's Google search, but what happened to John O'Keefe? So I'm curious to hear more from a juror. If a juror is speaking, I want to know more. I want to know more about that. But so another expert agrees with the defense expert. Okay. 32,000 texts. O'Keefe's death wasn't the first time in Norfolk County law enforcement found themselves facing allegations of cover-up and corruption. And we covered the Birchmore case a bit as indictments came down. The 2021 death of Sandra Birchmore, a pregnant 23-year-old who had been found hanging in her apartment. I'm not going to get into more details on that. It had been ruled self-harm. The following year, 3 Staunton police officers, the latter 2 twin brothers, were found to have engaged in sexual relationships with her after meeting her through the youth program. We covered that. And in June, this is what changed that case. In June, a forensic pathologist hired by Birchmore's family determined her death was homicide, not suicide. In August, federal prosecutors charged Farwell with murdering Birchmore and covering up the relationship and the resultant pregnancy. Quote, when it became clear to Mr. Farwell that he could no longer control Sandra Birchmore, he allegedly silenced her permanently, said Josh Levy, acting U.S. Attorney for Massachusetts. We covered that affidavit in other content. And this is what was interesting about that and is interesting to this case that we talked about at the time. Well, MSP said they had not found text between Birchmore and Farwell. The FBI found 32,709 texts between the two. Same person who did the extractions on the phone in this case. This is a horrible, horrible look for your forensic person. How do you miss over 30,000 texts? What the fuck? Just what the fuck? It looks like they're going to break down all of the things that go on to the side of this case. I want to hear more from the jurors. Let's see. I want to hear more from the jurors, hopefully. Let's see. let's get into other things. More statements from Yannetti. Never have I seen such unethical conduct from a prosecutor, Yannetti said in court, arguing for Cannoni to disqualify Morrissey's office from the case. She rejected the motion. None of us were shocked about that. But now they have a new prosecutor. We'll see. It said Reed housed Yannetti, Jackson, and Little and herself in the same hotel throughout the trial so they could maximize preparation time. Yes, if you have lawyers, then when they have to travel for trial, yeah, you have to pay for all of those bills. I wonder how much Murdaugh paid for his legal team for that trial. She paid $1.2 million leading up and during the 9-week court proceedings between her bail, accommodating, feeding, and transporting 3 lawyers, hiring private investigators and experts. For that, she used her savings of about $500,000 and her since depleted legal fund, about $400,000 donated by friends and family. She now has more than $5 million in deferred legal bills and a second trial looming. Yeah. The first one was trial on a budget, according to Reed. Since she couldn't fly out support staff from Jackson and Little's firm, Reed became the support staff herself. She negotiated rates with 2 Uber drivers to shuttle the team to and from court. Reed is aware her team, excuse me. Reed is aware her team had been photographed exiting, quote, discounted SUVs and surrounded by her volunteer security and dining out, the bill often picked up by friends and family members. As for criticism that her team occasionally enjoys upscaled restaurants, she says, you try feeding Alan Jackson McDonald's. I mean, fair. I mean, fair. Not wrong. Also, I don't know if just eating fast food is going to keep you feeling your best for trial. You know, Alan Jackson is like, I need to eat food. Quote, we don't typically work that closely with clients, said Little, who became partner during the trial due to her long hours. But in this case, we needed every hand on deck. Also, you're working with a client who's out of custody, who is a professor, who can help with other things, right? Quote, lock this whack job up is the next part of this article. About 10 months after O'Keefe's death, the Office of the U.S. Attorney, I want to hear more about this. I want to hear more about this immediately. About 10 months after O'Keefe's death, the Office of the U.S. Attorney for Massachusetts impaneled a federal grand jury as part of an investigation into unspecified federal crime related to Norfolk County's handling of the Reed case. The impetus is unknown. Levy will not accommodate on active investigations. Of course not. Nearly 2 years into the probe, his team has not yet reached a conclusion. When the FBI steps in, Emily gets to use her sound effect. When the FBI steps in, that usually is an indication that they are in possession of some information that is extremely damaging to the law enforcement agencies involved, said Tom Nolan, a 27-year Boston police officer turned criminal justice professor at Emmanuel College, who is not involved in the Reed case. Last year, the Alberts, McCabe's, and other witnesses were subpoenaed to testify before a federal grand jury, according to state court proceedings. It is incredibly logistically complicated to pursue a federal investigation into an active state murder investigation, in part because 2 agencies are interviewing the same witnesses simultaneously. Yup. That's coming from Zachary Hafer, a former federal prosecutor and Cooley LLP partner. Quote, I can't think of a time in my 14 years in the U.S. Attorney's Office where that happened. Presumably, it's some type of federal obstruction or witness tampering investigation, a cover-up of some sort. That is their speculation of what's going on. It is hard to know, but it is incredibly unusual that they happen at the same time. Incredibly unusual. In these types of cases, it is common for prosecutors to grant certain witnesses immunity to help them determine what happened and whether there is a provable federal crime. The U.S. Attorney's Office, they love doing that. The U.S. Attorney's Office has always prioritized the prosecution of law enforcement misconduct. Well, it's one of the things that they oversee on the federal level because it's really hard for agencies to look into themselves, it doesn't go well. Says Hafer, pointing out that making false statements to federal agency is a felony carrying a 5-year sentence. So even if an individual wasn't guilty of an underlying offense here, like a murder, lying about it after the fact to federal investigators is another potential charge. Shortly before the trial began, the feds provided more than 3,000 pages of findings to the defense and prosecution, including Proctor's texts. And then the defense went, well, there it is. Like, can you imagine? I can imagine Alan Jackson receiving Proctor's text going, are you fucking kidding me? And then being like, this is the best thing we've ever seen. This is the best thing we've ever seen. This is the best thing we've ever seen. Like, the level of defense attorney joy that would come up when reading these texts cannot be understated, because I would have, this is me speculating, because any attorney would be like, I fucking knew it. Because you get the sense that there was already suspicion and bad blood. These defense attorneys were like, what the fuck? This is sus. So getting the text message, they would have been like, oh, I fucking knew it. Right? We don't need to read these awful texts again. You guys know what they are. The federal investigation found that Brian Albert destroyed his cell phone the day before receiving a protection order to preserve it and its context. Right. And its contents. So weird that the day before you're ordered not to destroy your shit, the shit gets destroyed. That's so fucking strange. It's such a bad look. Albert said the timing was a coincidence and that he was due for an upgrade. It's just time for a new phone, babes. Also, on January 30th, Higgins, an ATF agent who had been at the Alberts and asked another federal agent for advice on extracting phone data. Months later, he drove to a military base and disposed of his destroyed phone and SIM card. Higgins testified that the target of a different investigation had found his contact information. Okay. That's still not how you would handle that. The explanation doesn't make any sense. But okay. The feds also determined that Higgins went to the Canton police station where he worked from after leaving the Albert home, though he was off duty and had been drinking. He said he was reshuffling cars. What's better than reshuffling cars in a police department parking lot in a blizzard while you're drunk? Because naturally. He spent much of the following day, a Saturday, when he was still off duty there, passing through the garage where Reed's car was eventually kept until about 6 p.m. The federal investigation found a 22-second phone call between Albert and Higgins at 2:22 a.m., 5 minutes before McCabe's alleged house long to die in this cold search. The men said that both the dialing and pickup of those calls were butt dials. Where? Though the federal findings were disclosed, Morrissey appealed to Cannoni days before the trial to prohibit mention of the federal investigation in court, arguing that it would be prejudicial. Cannoni approved the request, meaning Karen Reed's lawyers could not so much as use the letters FBI before the jury. What about the soundbite? Is the soundbite good? It doesn't matter, because some of the witnesses were like, oh wait, the federal investigation, like the shit was out of the horse. But they said in another proceeding. And the attorneys did a very good job of saying in another proceeding. The witnesses, however, weren't as good at it. And the defense was like, The defense was not mad about it. They were like, all right, well. When questioning forensic reconstructionists hired by the DOJ, for example, the most Jackson could say is that they were hired by an independent agency. Several jurors reportedly took that to mean they worked for an insurance company. That's interesting. I could see where, with a car accident, jurors could interpret that. Like that, I can see that being like, maybe this. How pissed are they when they get done with this trial and see all of this and are like, wait a second, what? Morrissey attempted to have the federal investigation transferred out of Massachusetts, arguing that the U.S. attorney in office when the probe began had been biased against him. Your Honor, that U.S. attorney hates me. We're not friends. He was unsuccessful. In a letter dated August 2023, the U.S. Attorney's Office told Morrissey to fuck off. No, that's not what they said. Stop it, Emily. That's not what they said. The U.S. Attorney's Office told Morrissey that Levy, quote, has a very different opinion of the circumstances in this case than as presented in Mr. Morrissey's letter. At some point, we need to go through those letters. And that the U.S. government, quote, believes it is essential to continue their investigation given the information of which they are aware. The U.S. Attorney's Office for Massachusetts would not confirm nor deny. Of course they won't. After finding 32,000 text messages that somebody managed to miss in a phone download, of course the feds aren't going to tell you about it. But things seem connected. Maybe they're not. Maybe they're not. Maybe they're not. The next title or the next section is a bargain with God. J. Michael RN. A little bit of both, apparently. Apparently a little bit of both. A Dedham courthouse is a 19th century Greek revival building that was the setting for what the New York Times described as one of the blackest pages in the American national story. In 1921, oh, we're going all the way back to the courthouse. In 1921, Italian-Americans Nicola Sacco, I'm going to pronounce these names terribly. Do not tell my Italian family members. And Vanzanetti, so Sacco and Vanzanetti, those names I know, were wrongly convicted of robbery and murder before being executed in 1927 in spite of international protest and overwhelming evidence of their innocence. 50 years after their death, Massachusetts Governor DOCKET absolved them, declaring, quote, any stigma and disgrace should be forever removed from the names. Reed faces her fate in the same building. The wildest moment during an already wild trial involved... Chat, let me know if you think this was the wildest moment in trial. It was a long trial. The wildest moment during an already wild trial involved security. It was flipped. That shit was flipped. Involved security video from inside the Canton PD garage during the crucial time between when Reed's SUV arrived and the taillight being found in Fairview. With Massachusetts State Police Sergeant Buchnick, Proctor's supervisor, on the stand, the Commonwealth played the video appearing to show that no one in the station went near the taillight in contention, the right one. The video showed the person Buchnick ID'd as Proctor behind the left taillight, though Reed and her lawyers say they hadn't seen the video beforehand. That's not okay. And it hadn't been entered during discovery. That's right. They all said it was just like, Canton just found it during trial. Hey, oops. There's video. And a lot of those are overwritten, so somebody must have saved it at some point. Let's see. Reed and her lawyers say they hadn't seen the video beforehand and it hadn't been entered during discovery. I think that's fact because the Commonwealth was like, oh, we just found it. But they realized during testimony that the spelling of police on the cruiser also parked in the garage was in reverse, and so were the letters or the numbers, meaning that what looked like the right taillight was actually the left. Quote, the timestamp was not inverted, which Jackson said, quote, means someone had to put on that inverted, the altered video on purpose. No one ever really cleared up how the video was extracted, why some was flipped, why some wasn't, why it was inverted. I think, well, I'm sure the feds are like, huh, isn't that interesting? Like all this shit wasn't flipped because the timestamps weren't flipped, but the video was flipped. So when does the video get flipped or unflipped? How does the whole system work? There are lots of questions there. During Buchnick's cross-examination, he admitted that the video was inverted, right? Because you can't reasonably deny that it's inverted. Shit's flipped. Meaning that the person Buchnick previously testified was Proctor was actually behind the right tail light. I'm like, are you kidding me right now? One of the jurors tells Vanity Fair. Huh. Yeah, the jurors were like, are you fucking joking? Really? This is bullshit. Quote, that was like, holy shit, they did this on purpose. This wasn't just an accident where they didn't know it was inverted. I couldn't believe that a Massachusetts State Police sergeant was defending this in open court. Oh, bitch. Yeah, the jurors were like, this is fucking bullshit. Trooper B testified he didn't know how the video came out to be inverted. It was just like, wow, what? The juror that talked to Vanity Fair has fucking thoughts. But I think those thoughts mirror a lot of the thoughts that were had in chat. For those of you in chat asking, awkward Cali girl said, how did Vanity Fair find the jurors? I have speculation, but I wonder, because the jurors were in contact with the defense team and someone reached out to the prosecution, I wonder if a third party put them in connection with the article being done, because it seems that some of the jurors had been in communication with the defense team. I don't know if anyone, not the lawyers, but if anyone on the defense team made that intro, like if you want to talk, you can. I don't know. But we know that the jurors had been in contact with members of the defense team and the prosecution. So it wouldn't be surprising that that connection could be made if the juror was amenable to it, with a, hey, I'll pass on. They want to talk to you. If you want to talk, here's their information. You reach out to them if you want to. I could see that happening. So, and then somebody could choose to talk or not to talk. So, but the jurors reached out to people. I mean, some of them were not quiet. They didn't want to be identified by name, but they had reached out. At certain points during the trial, Reed's team believed 3 specific jurors displayed visible disgust at certain prosecution side actions, such as Proctor's offensive text about Reed. I mean, I'm not surprised by that. The day of closing arguments, according to Kearney, one of the jurors was dismissed after a Massachusetts State Police officer who had been on one of the text chains with Proctor and who was in charge of the jury accused a juror of speaking about the trial at a bar weeks earlier. I don't know if we'd heard much in court about that. The officer did not respond to Vanity Fair's questions. I think, well, that has not, to my knowledge, been confirmed anywhere else. But again, Vanity Fair is reporting what they were told. In Massachusetts, alternate jurors are selected at the end of trial, not the beginning. So of the 14 potential jurors, 2 were removed after closing arguments. On the same day, the clerk pulled 2 tiles from a rotating box, bingo style. The magistrate did not show the numbers, but said they belonged to the other 2 potential sympathetic jurors. The chances of that happening are next to nil, said Jackson, referring to all 3 seemingly sympathetic jurors being removed from the deliberation pool. So with that, when courts draw numbers, they generally show the attorneys. It's weird to not show the attorneys to me, but a lot of stuff that happened in this courtroom was weird. And Jackson kept going, excuse me, Your Honor. And the judge was like, we do it that way. And Jackson's like, maybe we shouldn't. So normally they just show it. Okay. And I understand Jackson's frustration with that. It's like, just show me what numbers you pulled. Within days of Canoni's mistrial ruling, Reed's lawyers began hearing about the jurors who were disturbed by the outcome. 4 of them contacted the defense directly. This is what we're going to be hearing about tomorrow. The day of closing arguments, Albert and McCabe appeared in the courtroom's small gallery directly facing the jurors. We saw that. One juror said they felt intimidated by their presence, calling it completely and utterly inappropriate. They were substantial focal points of the trial. I can't believe they were allowed to stare down the jury. A spokesperson for Brian Albert says the O'Keefe family asked his client to attend. The jurors didn't like it at all. And the Commonwealth should have been able to read the room on that. Not a good look. Not a good look for the Commonwealth. And the jurors didn't like it. No wonder they're so mad. Reed, her lawyers, and her family spent 5 days on quote unquote verdict watch. Yes, we all call it verdict watch. In a church rectory near the courthouse, Reed was called back into court on day 2 for what turned out to be a question, but thinking it might be a verdict, she realized how unprepared she was. Could I be in a jail cell in 20 minutes? My first thought is I need to use the bathroom because I don't know when I'm going to have a private bathroom again. I couldn't find my brother. I was like, what if I can't hug Nathan? She says. At the end of the day, when the judge dismissed everyone, Reed broke down. Her head hurt so badly, she wondered if she had even been breathing. Then she began bargaining with God. I'll just take a mistrial. You can keep me in limbo for 10 more years. Just please let me go home tonight. On July 1st, Cannoni read the jury's note aloud, which I had, the internet would not let me be this day. Do you remember this last day of trial? The worst internet connection ever. On July 1st, Cannoni read the jury's note aloud, which stated that they were at an impasse. In the very next breath, Cannoni declared a mistrial. It was over like a guillotine drop, said Jackson, adding that Reed's legal team was given no information before that. Well, we've heard that in all the filings. Some wonder why her defense team didn't object. The judge has one primary responsibility in the trial, and that is to charge the jury correctly, said Jackson. When the jury comes back and says we're at an impasse, you have an additional responsibility to say an impasse on what? There's 3 counts here. It did happen incredibly quickly. However, I was also surprised that they didn't say, can we poll the jury? I wonder if Jackson thought they were going to poll the jury. And if Yannetti was just like, well, if Jackson's not objecting, I'm not objecting. There are so many ways this could have gone different, but we're here now. And I understand the jury's frustration. Within days, Reed's lawyers heard from 5 jurors who were disturbed by the outcome, 4 of whom contacted the defense directly. The jurors stated that the jury had agreed unanimously to acquit Reed on the murder and leaving the scene charges. It was the manslaughter charge that the group was split on. In an interview with Turtle Boy, a 6th juror alleged that 2 jurors wanted to contact Cannoni during deliberations, alerting her that they were unanimous on counts 1 and 3. That juror claimed that the foreman, the only person who can contact the judge and who is selected by the judge, said that they needed to be unanimous on all counts. I understand the confusion because that's what the jury instructions say. But also, it is my belief that if members of the jury say, can we contact the judge? They should be able to. And the 4-person shouldn't say no. The other juror said in an interview, we believe that he knew what he was talking about. I don't know if it would have changed things if we had asked the question about consensus on 2 of the counts. Yes, it would have. Yes, it would have changed things. In an August hearing, Reed's appellate attorney, Martin Weinberg, implored Cannoni to bring the jurors back and poll them on their votes on the 2 disputed charges, arguing that trying Reed again for second-degree murder would constitute double jeopardy. After Cannoni denied the motion, Reed and her lawyers took an appeal to the Supreme Judicial Court. A hearing is scheduled November 6th. We're going to cover that tomorrow, 8 a.m. Bring your pajamas or whatever your cozies are. And we'll just go to court early on. That's going to be at 8 a.m. Central, 9 a.m. Eastern. And we'll cover those arguments to the court. It shouldn't be a super long hearing, but we're going to hear we're going to hear Weinberg make essentially the same arguments that we heard them make before Judge Cannoni, just shorter. And then we'll get to hear if the judges ask any questions. That's what I'm most interested to see. We read the ACLU brief. One of Reed's few breaking points, it goes on to say, occurred when Jackson was arguing with the judge over the verdict slip, which offered jurors 3 guilty options versus 1 not guilty option. Cannoni said that's how the verdict slips look in Massachusetts, noting that Yannetti had certainly seen them. Yannetti said he actually hadn't. I disagree with you, Cannoni replied. When Karen smirked at what she viewed as another slight, Cannoni scolded her. This is funny, Miss Reed. The scolding made headlines and photos of Reed's smile underneath, but without full context. I mean, we just watched it go down. The judge was mad. Everybody had been in trial a long time. She also has a reoccurring nightmare that O'Keefe survived whatever happened to him on January 29th, but can't recall what that was. Reed is trying to get him to remember what? Reed is trying to get him to remember what unfolded after he got out of her car, but there are two other people in her dream, Peg and Paul O'Keefe, and are telling O'Keefe that Reed tried to kill him. The dream haunts her as much as the reality that O'Keefe's family, who did not really know the McCabe's and Alberts before O'Keefe's death, has sided with the Canton families. Reed brings up the quote, "It's easier to fool someone than to convince them that they've been fooled." Reed believes this captures the O'Keefes. She says that Peg never fully embraced her when O'Keefe was alive, perhaps because of the difficulty of seeing another woman help raise her daughter's children. Okay. Reed thinks back to the morning of January 29th when Peg seemed to blame her immediately, but the O'Keefes did not seem to hold it against Albert that he never emerged from the house as emergency workers tried to save their son. I think that part is a fair question. We all ask that question. But you don't come out of your house, though? Also, I can't imagine the grief that Peg O'Keefe has gone through the morning that she finds out that the third guardian for her grandchildren is dead, that she has lost a second child. So, but I think there are questions for why nobody in the neighborhood came out of the house. Like, seemed weird to me, seemed weird to y'all. Ashley, I see your comment. I will go back and take a look as we finish the article. Reed thinks back to the morning of January 29th when Peg seemed to blame her immediately, but the O'Keefes did not seem to hold it against Albert that he never emerged from that house as emergency workers tried to save their son. That doesn't bother you in any way, but in an instant you believe that I somehow flipped out and committed my first crime, Reed says to me, and here she begins a blow-by-blow rebuttal to the O'Keefe family criticisms. So Paul and Peg, if you think I killed John, that means you misjudged me for 2 years and entrusted 2 young family members in my care. Then in the blink of an eye, you now think I'm a cold-blooded killer who took away your son. After trial, Paul gave an interview to WBZ-TV, quote, "We know that Johnny and Karen were arguing, and it was kind of towards the end of their relationship. They were drinking and arguing and fighting. I don't know if I think they were fighting that night." Until she started leaving him mad voicemails. I don't know if anything shows they were fighting that night. They were drinking and arguing and fighting, and in an intoxicated state of rage and jealousy, again, this is Paul O'Keefe, she just decided that she was going to do something about it. Again, that's Paul O'Keefe, said he was convinced of Reed's guilt the morning of his brother's death when Reed told his wife, Erin, that she needs to remember the bad times. Quote, "If being innocent and enjoying the support and refusing to be down day after day, month after month, year after year makes me America's happiest murderer defendant, then I'm America's happiest murder defendant." What? I'm going to need context for that hero quote. Reed confirms that she said, quote, "That was my processing, my trying to think of reasons not to mourn or miss John. Quote, I am capable of meeting other people. What do you think? I don't want anyone else to have him. He's got to be dead. I can't handle this fight we just had," she says, firing off her rebuttals as though her antagonists are in the home with us. And then I'm going to murder him on the front lawn of the most powerful guy in town who's an acting police officer. We argued, Reed's admit, but was I abusive? Was I neglectful? Did I mistreat him emotionally or in any way? Or did we have ups and downs? And I helped him tend to the kids, and we went on vacations and sporting events and school and breakfast and haircuts. In the same interview, Paul said he's bothered that O'Keefe's death is being overshadowed by what he called the Karen Reed show. I get it. I get it. I get it, but I think that is not unique to any trial where the focus is on the defendant and what did the defendant do or not do, and will they be convicted or not convicted. That is the focus of criminal trials. And I get how frustrating that is, but that is the focus of criminal trials. And I think we've seen that in a lot of, especially the criminal trials we've covered, is the frustration from family members saying everything's focused on the defendant. Yes, their constitutional rights is the focus. What the defendant did is the focus. And what happened to the victim can't be focused on as much because it could be prejudicial. A jury can't decide a case based on sympathy for the victim. They have to look at the case and look at, did the things that the state is saying happen, are those things a crime? And if they are a crime, were they done by the defendant? So I can understand the family's frustration. I absolutely can understand it. So I get the frustration. I do. But that's also the difficult thing of criminal trials. So let's see. Paul, it's clear that Paul is not happy. So Paul said that his brother's death is being overshadowed by the Karen Reed show. The O'Keefes declined to answer questions from Vanity Fair, but sent a statement declaring that the family believes she's liable for John O'Keefe's death. They are in the middle of a civil lawsuit. I'm not surprised the word liable was used. Unlike most people accused of murder and sued for wrongful death, Karen Reed has embraced her celebrity in outsized ways. After noting her media appearances and the fact that she did not testify at her first trial, the statement concludes thus, this intensive media campaign to influence potential jurors compounds the O'Keefe's family's terrible loss while delaying and denying her accountability. We know that they're mad. And their grief can't overshadow her right to a fair trial. And everybody's, again, prosecutors work for the Commonwealth in this case. The Commonwealth of Massachusetts deserves answers. The residents of Massachusetts deserve answers. Can their police force investigate a homicide and come to a sound legal conclusion? The community deserves those answers. The O'Keefes deserve those answers. And Karen Reed deserves those answers. But that should be the goal of a prosecution, is to find the truth and to do justice. Let's see. It goes on to say, Reed has a response to claims she's embracing the spotlight. Quote, anyone in my position who's being falsely accused would be shouting from the rooftops. First of all, I don't want to be here. It can be called the John O'Keefe show. It can be the O'Keefe family reunion, she says. Oh, I get that she's mad, but it's hard. But if you think for a second that anyone has fought harder to find the truth about what happened to John and to enlighten everyone about what happened to John harder than me, you're wrong. I can understand that. Because the answer of what happened to John, she maintains, shows that she did not do it. Everyone should want that answer, including the O'Keefe family. Paul stationed himself feet away from Reed in court, glaring at her throughout the trial. Did that bother her? Quote, you can't have no respect for someone and care what they think. Oh. She's like, I don't give a shit about him. I have no respect for him. I don't care. I don't think it's a good look for the jury, though. I don't. You can't have no respect for someone and care what they think. I didn't do anything, so you can stare at me and get an ulcer over your hatred toward me. She said, the O'Keefes never carried a pitchfork for me until I started getting support. You didn't speak to any media. Now you're giving interviews. You really just can't stand my rising from the ashes. The only thing that changed is that I started to come from a position of power. They really aren't happy with each other. Quote, John, if you can hear me. In August, O'Keefe's family filed a wrongful death lawsuit against Reed, the Waterfall, and C.F. McCarthy's, the later being the two bars we know. We went through that lawsuit. Let's see. Reed not appearing. We talked about this earlier. Reed denies that she was overserved. Every witness at trial testified to Reed not appearing drunk. That's accurate. And has sought to delay the civil suit. Well, has sought to delay her discovery in the civil suit until her criminal trial. Quote, they would have done this 3 years ago if this was about John, she says. Only when I walked out of the courthouse a free woman did they seemingly put the wheels in motion to sue me. O'Keefe's father is a family member. O'Keefe's father is a family member whose coldness hurts most. Reed and John Sr. used to go to Sunday Mass together, then take Patrick to breakfast. She shows me the Christmas card he gave her a month before O'Keefe's death. Quote, "Dear Karen, my mother always told me if you want to tell someone how you feel, do it in a letter. So here goes. I finally figured out who you are. You are I don't know why it's in paren, but you are an angel sent from heaven. And thank you so much for all you do. You are the best of the best. Love you forever, Papa." Oh, angel in heaven appear in parentheses in the card. Emily, keep reading. "I didn't think he wants any of this fighting and this war," says Reed. "Nevertheless, we're at war." She wakes up some mornings to iPhone memories showing her past life with the kids. The images used to hurt. Now they just make her mad. They've been exploited and brought into trial they had no business being in, Reed said. "The hope for me is that one of them will really dig into the case one day and be ambitious enough to say, 'I need to see everything,'" says Reed. "Or there will be a federal indictment and my allegations will become even more validated." Reed has been criticized for not looking like a grieving girlfriend in the courtroom. I mean, I don't know. I try not to give too much about what people look like in court. There are moments, but sitting stoically while your trial is going on has to be incredibly difficult. Lawyers, on the other hand, have a whole different realm, but the defendants themselves, it has got to be incredibly tough. Reed has been criticized for not looking like the grieving girlfriend in the courtroom. Quote, "I have mourned and cried over John O'Keefe, but this is not productive now. I don't feel the acute sadness I did when I first lost him. She realizes people may not understand this. If that sounds callous, I'm not going to apologize. We weren't married. The public is now hearing a lot for the first time, and they have to realize I've gone through these stages of grief. I've reached the point that, John, if you can hear me, I've done everything I can. I don't think your family can be saved. They want to see me incarcerated for the rest of my life, despite never seeing evidence while you were alive that I mistreated you. We were dating for 2 years, and I've since eclipsed those 2 years. I'm going on 3, and I've got to save myself now." On another of my evenings with Reed, she and I join her parents, Bill and Janet, and her brother Nathan and his friend Adam for dinner at one of the family's favorite Providence restaurants, El Forno. Bill is earnest, analytical, and plainly and worked hard to give his family a good life. Quote, "I've never had to worry about the police, and now I look with a very skeptical eye at everything." Quote, "There were layers of accountability that should have remedied anything corrupt," he tells me. His daughter, quote, "is just collateral damage. It sounds heartless, but it's true." Janet, a stylish woman whose father was a cop and who met Bill when they were both working at Bristol Community College, can better compartmentalize. She is warm, bubbly, half Italian, the meal's mood booster. That read awkward to me, but maybe it's because I'm tired. She makes sure I've tried the squash blossoms and wants to know whether I've seen Masterpieces Endeavor, the show involving murder investigations. It's been a welcome escape to a different time, the 60s, place, the UK, and moral compass setting. Janet points out the patrons around us have no idea what the family is going through. Quote, "People cannot hear what we're saying. They just see us and think they have a lovely life. They're just floating along." I don't know if anyone in Massachusetts doesn't know what this family is going through. You guys let me know what you think. Reed couldn't share confidential information about the case with her family, so her parents and brother had no preparation for some of the things that came up in trial, like Proctor's horrific texts. Oh, I didn't know that. Her family didn't know about the text? "It's not easy," said Janet. "I knew Karen was going to give me a look if I made even a breather of a sound, but I was frustrated." Bill says he appreciated that Cannoni made Proctor read the entirety of his profane text about Reed rather than let him censor himself to the jurors. Yeah, I appreciated that too. Because Cannoni was like, "Did you say it or did you spell it?" And he's like, "I said it." She's like, "Then say it. Your words, put them out of your mouth." It was a great objection. This moment was a great objection by Alan Jackson, where he's like, "Your Honor, no. It does not spell it out in those texts. Say it. Say it. I appreciated it. I was just like, yup. Say it out your mouth. You typed it, you say it. Bill says he appreciated that Canoni made Proctor read the entirety of his profane text about Proctor rather than let him censor himself to jurors. When she forced him to say that "see you next Tuesday" word, I wanted to go up and shake her hand. I think every one of us was like, yep. Make him say it. He said it. Reed's father says it needs to end, and Bill tells me his dessert arrives, and it needs to end in a manner that puts some of these people behind bars. Quote, but Dad, if someone came up to you right now and said they're dropping the charges, there will be no further indictments. You will never step foot in another courtroom again. You'd go to sleep with a smile on your face, said Reed. We don't need anybody to be indicted. We'd love it, but we don't need it, he agrees. Just be free of my family. Reed has been criticized for smiling and waving at her supporters, a jarringly dissonant display, but she has no apologies. Quote, I implore any critic to get out of the car in the middle of a walking nightmare, see 200 people wearing your favorite color, telling you to keep your head up, to keep your spine strong, and you don't crack a smile. It has been a lot worse. I've been frog marching into... I don't even know what that idiom is. I've been frog marched into court with shackles on my feet and clothes that I slept in jail cell the night before, in front of cameras, to all negative headlines. And the only people in my corner were my parents and my brother. I can't not smile. I just feel God's presence. Reed saw a Daily Mail headline calling her America's happiest murder defendant. Quote, if I look happy, did it cross your mind that I have a free conscience because I didn't do it? If being innocent and enjoying the support and refusing to lay down day after day, month after month, year after year makes me America's happiest murder defendant, then I'm America's happiest murder defendant. Oh, that's the hero quote. It needed context. On my final night with her, Reed plays DJ on Spotify and tells us about the temperature-controlled storage unit she's been paying for to house the carpeting torn out of the Alberts. What? Wait, what? Wait, what? On my final night with her, Reed plays DJ on Spotify and I want to know the music, and tells us she's been paying to house the carpeting torn out from the Alberts home after they sold it last year. How did that happen? She hopes one day she'll have the money to swab it for blood and DNA. The Olympics are on TV and no one's paying attention. I mean, what Olympics were on TV, though? Was it rugby? Because how do we know? I have so many questions. Where is the carpet from? Like, where is the carpet from? I have questions. Where is the carpet from? I'm gonna need more information. Did you buy that TV in 1992? Jokes the security guard. Actually, John hung this, so I got it in early 2020. He was very good about doing projects. He was handy, said Reed. I asked if she gets sentimental about stuff he bought or did in the house. She said, I was in the beginning, but when a significant other dies, he's gone and there's no choice. You've got to pick up and move on. A friend recently asked Reed if she's dated since O'Keefe. I've had a couple of connections, but I haven't been in a relationship. No, she's been in court. Court is the relationship she's in. She told a friend who expressed surprise, which annoyed her. I didn't do anything wrong. Well, you're in court. I mean, she's in court. I don't imagine how she has time to date. Reed's feelings for O'Keefe have become more complicated the longer her legal saga stretches on. She was heartbroken, but now feels trapped in a wretched afterlife of their relationship. I feel that everything in the 2 years I dated John was a precursor to this horrible decision of us to go out drinking, and for John to think he was welcome with these people who never really acted welcoming to him before. Each witness I see come into court, each cop, each Albert, the girls from Aruba, it's like this all came into my life by way of John. Everyone was a drinking buddy. Everyone testified as much. Alcohol's the epicenter of this. I don't disagree with that. And it was in my relationship with him. In hindsight, everything was just a precursor to this fateful, tragic night in his life. and to a much lesser degree, mine. Reed does not drink as much as she did with O'Keefe and was initially reluctant to order the occasional alcoholic beverage at a restaurant, worried that people would judge her. Well, I mean, people are going to judge no matter what at this point. She has since stopped caring what strangers think. You're allowed a cocktail if you're being framed for murder. Well, I mean, if she's out eating, people are going to judge. If she's whatever she's ordering, people are going to judge. So I get it. Each morning she Googles herself. Don't do that. That's not going to help at all. She clicks on the new tab, sorts the articles by date, and reads the most recent headlines to see if there have been breaking reports overnight. Then she heads to the mass.gov to see if any new filings have been added to the docket, but she is a prisoner to her iPhone. Humor has bent to circumstance. When I drive Reed to lunch, she brings up a toast her brother made to her at his wedding, saying he didn't know if he'd ever repay her for the support she gave him during a previous breakup. Little did I know he'd get to drive me to my criminal trial, she cracks. At one point during our visit, the security guard asked Reed whether she's ever worked with a therapist. No, never. That's what you guys are here for, she laughs. Can they make me not look out the window constantly to make sure the police aren't there? I mean, I feel like therapy would be helpful. But I also understand when you're looking at $5 million in legal bills and you've lost your health insurance, that therapy might be at the bottom of that. After Reed's mistrial, Canton Police and Massachusetts State Police disciplined some officers. Proctor was suspended without pay. Proctor's supervisor, Buchnick, lost 5 vacation days. We talked about that. And Kevin Albert was suspended for 3 days. Others have remained untouched. Canton Lieutenant Paul Gallagher, a 30-year veteran who collected O'Keefe's blood evidence in solo cups and stored them in a Stop and Shop bag, made $322,000 plus last year and recently announced his retirement. Lank, one of the officers who neglected to interview the Alberts on the record or search their home, was promoted to lieutenant in August 2022 and made over $247,000 last year. They know that because those are all public record, and is still on active duty. When I visited not the Stop and Shop bag. When I visited the Canton police station if you're reading this article and didn't read the trial, I understand you've got to put the photo in because I was stunned. When I visited the Canton police station on a Wednesday in July at 4:15 p.m., it's completely empty on the first and second floors. The dispatch center is dark. The lounge is outfitted with armchairs and silver scales of justice resting on the table between. One side is tipped fully to the table. In September, Canton residents protested outside the station, demanding an independent audit and declaring that they feel unsafe in their community. I mean, I think the feds are doing that independent audit, but they don't know what the result is, so I understand the discomfort. Nolan, a BPD officer turned professor, predicts that Proctor's punishment is temporary. You can't get fired for incompetence as a police officer. I mean, we'll see what else happens. You can't get fired for incompetence as a police officer. He is backed by MSP Union, which issued a statement saying it is disappointed by Proctor's suspension. That's true, which was surprising in lieu of the text messages. Nolan points out that MSP's union's own corruption history. In 2022, the former president was accused of running the organization as a criminal enterprise from the police union and sentenced to 30. Wait, there were RICO charges from the head of the police union. Okay, I'm less surprised about them being disappointed by Proctor's suspension. What? Nolan points out that Massachusetts State Police Union's former president was accused of running a RICO organization with the union and sentenced to 30 months for racketeering, obstruction of justice, and tax crimes. What? How does it keep getting worse? In 2022? That was in 2022. Now I'm wondering what's taking the FBI so long. What? In September, the governor announced new leadership for Massachusetts State Police. Jeffrey Noble, who's a lieutenant from New Jersey State Police. The first time someone outside Massachusetts would run the organization in its 160-year history. Yep. Noble, who took office in October, declined to answer. Of course they did. This is new information. Nolan says that's a baby step in correcting a 2,300 person organization so infamous for the scandal that Martin Scorsese made a movie about it. Reed still thinks The Departed is a great film. The criminal defense attorney who was previously quoted said, quote, "The Reed case has caused such turmoil within the rank and file. I think it's likely that Proctor could end up being terminated." I think so too. I don't disagree with that. Quote, "100% I believe that she was framed," said the juror who spoke to Vanity Fair, citing the medical examiner's testimony. That's interesting. And that the Commonwealth accident reconstructionist failed to convince this person that a fatal vehicular collision occurred. I'm not shocked by that. I'm not shocked by that. That the juror is like, the state's reconstruction expert didn't, there was like a pirouette. And yeah. Quote, "I still can't wrap my head around the fact that this is possible within the Massachusetts State Police and Norfolk County District Attorney's Office," the juror said. The district attorney's office should be feeling some kind of a way by these statements. There's so many people involved in this, the people you're supposed to be able to trust. That should be important to the DA's office. Bill keeps running count of the days the DOJ has been Bill Reed's father keeps a running count of the days the DOJ has been investigating his daughter's case or the investigation thereof. Reed has a hard time believing the U.S. Attorney's Office would have committed so much time and resources if they were not building a case. I don't disagree with that. Meanwhile, according to sources, Morrissey's top prosecutors have refused to retry Reed's case, so he has taken the unusual step of retaining outside counsel to spearhead the next trial. When will elected DAs listen to their line prosecutors? Listen to your line prosecutors.
Bruh.
When your line prosecutors are telling you that they refuse to try the case, it's because they know shit. It's not because they don't want to go to trial. It's because they know shit. Ugh. Meanwhile, according to sources, Morrissey's top prosecutors have refused to retry Reed's case. Yeah, I understand why. I imagine numerous prosecutors looked at this before filing and went, the fuck? One of the most important jobs as a prosecutor is choosing which cases to take and which cases to not take. Wow. So Morrissey was like, no problem. Let me go spend more money to hire somebody else. Hi, Dr. B. What's up? Yes. What time? Oh, it's almost 4. Okay. I'm almost done. What time are you leaving to pick up G? Give me 10 minutes. Give me 10 minutes. Okay. And then we can do that. Yeah, everybody is just terrifying Emily. I was in the middle of a rant. Scared the crap out of me. Okay, so the prosecutors don't want to retry the case. So instead, they're going to bring in outside counsel.
Bruh.
So now we have defense attorneys who were prosecutors and prosecutors who were defense attorneys. That worked out so well for Gary Morrissey. Oh boy. Oh boy. I'm not surprised that line deputies who don't want to be named made their feelings known in this. Not that Not that I've ever seen prosecutors at other offices do the same thing, but sometimes you understand what the vibe of an office is about certain things. It's not always a secret. However, people also don't want to be fired. Though I'm not surprised that multiple prosecutors were like, you try it yourself. I'm not doing this. They still have an independent ethical duty. And if their boss comes to them and says, try this case, they can say no. I said that about Lally. Say no. So now we've got Hank Brennan, who's like, I'll just bring in a whole new investigation between now and April. It's a good, nice view. All right. This has to be the end of this. Though this chapter of her life has been dark and arduous, Reed tells me she's witnessed the best and worst of humanity because of it. Quote, the evil people in my life, you know who you are, she says, once again directing her answers towards people who don't hear her. You know what you did. I am at peace with my maker, and you, I promise, are not. That's a little ominous. Do you think, is that ominous? Reed feels a momentum towards justice. It's starting one domino after the other. I mean, the defense team has to be bolstered by the fact that the line deputies were like, fuck no, I'm not touching this case. I get it. Reed feels a momentum towards justice. It's starting one domino after the other, she tells me. I just don't know how long the trail of dominoes is. Are there 10? Are there 100 more? I don't know how long it takes to get there, but I know there's a big explosion at the end. Well, that sounds ominous too. It's going to be very interesting to see what the feds do and if the feds are able to bring forward their results before the trial starts in April, if April is when this goes to trial. So I understand the frustration in this case from all sides. I do. I have empathy for the victim's family. I absolutely do. But this investigation is just not an investigation that brought about answers. I'm not surprised there's been an overhaul at Massachusetts State Police. It seems not just because of this case, but others. When you have a tech expert who's like, I didn't miss anything, and in another case missed over 30,000 text messages, how do you put that person on the stand with a straight face and be like, this person is telling the jury what they believe? When you have jurors coming out after trial saying, I 100% believe that she's been framed, and I was looking at the witnesses going, just shut up and answer the question, that is not a good position for the prosecution to be in. The prosecution could choose not to retry this case. They could. They could have let this stand and say, you know what? The jury was unable to reach a verdict. We don't think a retrial would be fruitful, but they're not going to walk away. And everyone's just locked in horns on this case. But it shouldn't be personal for the DA's office. I understand why it's personal for Karen Reed. It is, in fact, her life. But the DA's office needs to be able to take a step back and actually evaluate the facts of this case. And it seems like in evaluating the facts of this case, new counsel has said, I've got a solution. All new experts. I mean, it's easy when you're spending the taxpayers' money, I guess, to be like all new experts. I'm curious about where that carpet came from, like where in the house the carpet came from and how they obtained it. I have more questions. Chat, I'm glad we went through it together. Mods, thank you for rolling for a 5-hour stream. I'm sorry. And also, thanks for hanging with me today. This is, it's an interesting choice to sit down and give access like this. But it is her choice to make, knowing full well that all of this can come back to bite her. I think Karen Reed seems settled in the fact that nothing I'm going to say is going to change anything, because what I am saying is consistent, because what I am saying is the truth. And this is what I have consistently said. So I don't think she's worried about it, because otherwise she wouldn't have done this. But this case, I have focused on the fact that the prosecution has to prove what happened. I don't think they did that. I don't think the investigation leading up to this case would allow for them to do that. And I don't think the evidence matches their theory of the case, period. And then you pile everything else on top of it, and the butt dials, and the missing phones, and the rehomed phones, and the dog, and that raises a lot of questions. And then we know that the feds have brought indictments in another case involving the same agencies. And so now I think all of us are just waiting. What are the feds going to do? And are they going to do it before a retrial? Feds. The FBI. Hey, this might get continued till April. We would sure love to know. I mean, y'all were doing this as this case was run into trial. We love the crash daddies. They made sense. So what's going to happen between now and maybe April? Because I want to know. I want to know. Well, I think Karen ended her interview with Boom Goes the Dynamite. So with that, we are going to wrap up here because I am going to be up early. We're going to go back to Massachusetts in the morning. And when we go back to Massachusetts in the morning, we are going to be covering the oral arguments before the Supreme Judicial Court. So tomorrow morning, I will see you bright and early, 9 a.m. Eastern. Also, for those of you that have not gotten all of your delights from the Law Nerd Shop, remember, the Legacy Law Nerd Shop is going away on Friday. We will be relaunching Law Nerd Shop 2.0 with all new designs later this month in time for the holidays. So if there are legacy designs that you love that you have not gotten, lawnerdshop.com. We have put all that information in the app as well. The Legacy Law Nerd Shop is closing its doors forever. And Shop 2.0 is going to be rolling out with new products, new designs, and an entirely new look and feel. I am very excited, but if there is something that you love, now is the time. There will not be mugs and there will not be fax hats in this next round. It will be a minute. So if you have a few legacy favorites, now is the time. And because we are getting rid of the tumblers, they are BOGO. So if you want to buy one, get one on the tumblers, go grab them now. The only asterisk to that is Canadian Law Nerds. Your tariffs have made it very difficult to ship these to Canada. So I am sorry that the BOGO does not exist for Canada, and we cannot ship the tumblers to Canada in this round because the tariffs have changed. So we will be relaunching down the road some of the legacy designs, but for now, even when we release the legacy designs, they will be new product because we are changing all of our distribution and all of our sourcing. So we are changing over our entire shop, including sourcing and distribution. It will allow us to bring you more custom items. It will allow us more control of quality and international shipping. For those of you asking about Europe, yes. I'm sorry, Canadians. We will be back. We will be back to shipping in Canada. These tumblers with the tariff just cannot ship to Canada right now. So the BOGO is not in Canada. With all of it, y'all, thank you for being here. Thank you for rolling with me on this Tuesday. I'm going to go vote with Dr. B. We're going to go pick up our kiddos. Try not to doom scroll this evening. Remember, we've got court in our cozies tomorrow. Whatever the day brings, we've got court in our cozies tomorrow. We're going to just listen to some oral arguments tomorrow. Thursday, we're going to go to music court. It seems that we're going to have to revisit the Sarah Boone pre-trials of it all. Hopefully, Judge K, the Law Nerds would love it if you set a date for that motion for new trial. We really, we need something to look forward to. And then this week I get to go see Creed. So I have things that I'm focused on. Hopefully you do too. Don't forget to feed your Snorlax if you're playing Pokemon Sleep. I need to go do that. I appreciate you guys. Take care of yourselves. Take care of each other. We are Law Nerds, y'all. We've got this. I appreciate you, and I will see you soon. All right, Law Nerds out. Thank you, mods. I'm sorry. Tomorrow's going to be early. Love you guys. You're the best. Bye.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.